believe that it's supposed to be, okay, yes, sorry.
Okay. The Colorado Bar Association may use portions of this as kind of advertisement for these mock trial tournaments. Please be aware of that. If there's anyone in the gallery who's not connected with teams or who is connected with teams that are not competing, please exit the courtroom. I want to remind you all that we will not be taking any recesses unless there is an emergency. If there is an emergency, obviously, please feel free to chime in. We're going to be understanding of people's needs and certainly don't want to risk anybody's health or anything of that nature. Scoring panelists, I'd like to ask you now if you have any reason to believe that you would be biased against either team.
No.
Okay, I'm seeing all heads shaking no, and I heard a couple of verbal no's. I will take that to mean there is no reason to believe there's going to be bias. If there is any dispute during this round, it must be reported in accordance with the competition rules. Your compliance with time requirements is going to be enforced. You have your own time monitors. However, the scoring panelists may add, reduce points as they see fit based on time. We don't have a jury box, so I can skip this next one. Okay, I'd like, starting with the prosecution, please introduce your team members, attorneys, and witnesses.
Hello, my name is Bailey Burton. I'll be presenting the opening statement, conducting the direct examination of Alex Cifuentes, and the cross-examination of Taylor Perkins.
Good afternoon, Your Honor. My name is Marcus Winton. I will be conducting the direct examination of Ms. Kyle Kuzak and the cross-examination of Professor Blake Van Owen.
Good afternoon, Your Honor, members of the jury. My name is Angel Hernandez. I will be conducting the direct examination of Detective Jordan Markowitz, as well as the cross-examination of Ms. Avery Becker. I will also be presenting the closing statement for the prosecution. May our witnesses now introduce themselves?
Please.
Good afternoon, Your Honor. My name is Paige Flunchy, and I am Detective Jordan Markowitz.
Good afternoon, Your Honor. My name is Sherry Rangel, and I am Alex Cifuentes.
Good afternoon, Your Honor. My name is Andrea Hernandez, and I am Kyle Kuzak.
Thank you. And from the defense, can we have introduction of attorneys and witnesses, please?
Your Honor, opposing counsel, and members of the jury. My name is Jaden Inks, and I will be delivering the opening statement, giving the direct examination of Professor Blake Van Owen, and giving the cross-examination of Alex Cifuentes.
Your Honor, opposing counsel, and members of the jury, my name is Brendan Maher. I will be delivering the direct examination of Taylor Perkins and the cross-examination of Kyle Kuzak.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Will Damon, and I will be delivering the direct examination of Avery Becker, the cross-examination of Detective Jordan Markowitz, as well as our closing argument. Your Honor, at this time, our witnesses would like to introduce themselves.
Please have them do so. Thank you.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Christian Murray, and I am Blake Van Owen.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Jet Fisher, and I am Taylor Perkins.
Good afternoon, Your Honor, opposing counsel, and member of the jury. My name is V. Wing, and I am Avery Becker.
Thank you. At this time, I would ask everyone to raise your right hand as I swear you in. Team members, please raise your right hands. Do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor. Yes, Your Honor.
Okay. And scoring panelists, please raise your right hand. Oh, I'm sorry, gallery members, including teacher and attorney coaches, family members and friends. I don't know that we have any. Please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? Don't have any. Then scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Yes.
Okay. Then I believe we are ready to proceed to preliminary matters.
Yes, Your Honor.
Okay, from the prosecution.
Yes, Your Honor. First, we would like to clarify that pursuant to Rule of Competition 7.4, for the purposes of our online competition, exhibits that are displayed on the screen will not be shown to the jury unless we specifically request to publish. Exhibits may be shared on the screen for purposes of identification prior to admission.
Thank you for informing me of that.
Additionally, while each of our attorneys and witnesses have made efforts to be in a setting with the best internet capabilities possible, if at any point the court cannot hear or see us, please feel free to interrupt us at any point.
Thank you.
Your Honor, for the record, all witnesses will be present for the trial today and may not be sequestered pursuant to Rule of Competition 5.3.1.
I agree with that interpretation unless there's an objection from the defense.
No objection.
Okay.
Lastly, we would like to request that stipulations and jury instructions be constructively read into the record.
They will be constructively read at this moment.
That is all. Thank you.
Thank you. From the defense?
Yes, Your Honor. On behalf of both teams, let the record reflect that our trial rosters, I believe, have been shared with you yourself and the jury for clarification of all of our team members.
I agree. Thank you.
To clarify on Rule 7.4, we do agree with this. When an exhibit is shown to a witness, a member of the examining attorney's team shall make that document available to all participants via a screen sharing, via Zoom screen sharing or similar technology, as well as these exhibits or other documents posted in this manner must be not shown to the jury until the counselor has admitted it into evidence and fully published it. However, pursuant to Rule 4.7 of the competition, no enlargements or edits made outside of the testimony today are to be used within this case in openings, closings, cross-examinations, and directs. However, pursuant to Rule 7.4, we can zoom in during the trial. These enlargements cannot be made, however, outside of the trial.
Okay, do you have any disagreement with that interpretation, Madam Prosecutor?
No, Your Honor.
Okay, please continue.
We also understand that sound quality and internet connectivity may vary. We ask that the court pause time if any one of our members or opposing counsels, witnesses or attorneys cuts out, and allow them to re-ask the question or the witness to be able to answer fully to their best of their capabilities that we can using this platform.
I certainly agree with that idea. Technology failure is not the fault of the team. If that is in agreement with the rules, I think that's how we should enforce it. Madam Prosecutor, what do you think?
I totally agree.
Okay, well then, timekeepers, please be aware if there is a clear disruption between a witness that is the fault of technology, please stop the clock.
Your Honor, we also request the court's preference on recrosses.
I prefer not to do a recross. However, if there is a good reason, perhaps new territories explored on redirect, I'll certainly leave open the possibility, but it is my preference not to do recross.
And Your Honor, we ask that our timekeepers and the other timekeepers, and the timekeepers for the other team are allowed to post our time remaining in the chats to keep us accountable for our time, as well as to help you and the jury with the timing of this trial, as it is a timed competition.
Absolutely, I think that's appropriate. Again, Madam Prosecutor, do you have an objection to that plan?
No, Your Honor.
All right, then that will be what we'll do. Timekeepers, please post remaining time in the chats as appropriate.
At this time, we have no further preliminary matters, Your Honor.
Okay. Then are there any motions in limine, or are we ready to proceed to opening statement?
The prosecution is ready to proceed.
The defense is ready to proceed.
All right, please then, Madam Prosecutor, whenever you're ready.
Your Honor, before I begin, can you hear and see me all right?
I can. Feel free to be seated if you're more comfortable in that position. However you prefer to present, that's what you're welcome to do.
Yes, Your Honor. May it please the court.
Yes, please proceed.
A knife in the back. On March 6, 2020, Avery Becker made a rash decision and confronted her coach about their disagreements in the past. But like most rash decisions, things didn't go as planned, and Mackenzie Brackman was found dead later that day. However, this type of decision wasn't unusual for Miss Becker. In fact, just before, she had made another rash decision and vandalized her coach's car, writing Worst Attorney Award across the hood of his beloved Porsche. This is just one example of Miss Becker's rash personality. However, throughout this trial, this topic will be brought up time and time again, as Miss Becker's former teammates and even best friend have previously described this trait in their affidavit. But let's talk about the day the murder took place. On March 6, 2020, Avery Becker and Taylor Perkins, who claims to be Miss Becker's best friend, skipped school to look for Miss Becker's alleged lost phone. Miss Becker claims to have lost her phone just the day before the murder took place, even though it traces her to being at the victim's residence at the time the murder took place. This is also the same phone that Miss Becker had previously used to admit her plans of breaking into Mr. Brackman's house to former teammate Alex Cifuentes. However, as I previously stated, Miss Becker claims to have lost this phone just one day before the murder took place. Isn't that convenient? Throughout this trial, the defending party may try to distract you with alternate theories and even the victim's personality himself. However, as the prosecution, we have the burden of proof in today's case. We have to prove beyond a reasonable doubt on March 6, 2020, Avery Becker unlawfully and feloniously committed the crime of second-degree burglary, and in the course, the death of Mackenzie Brackman occurred. For us to prove our case beyond a reasonable doubt, we must not eliminate all possible doubt. After all, everything in life is open to some possible or imaginary doubt. A reasonable doubt is such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. Which is why, at the end of today's case, there will be no reason to hesitate. After hearing all of the evidence, we will be able to prove that Miss Becker committed the offense of second-degree burglary and murder in the first degree. You'll hear from Detective Jordan Markowitz, who's a certified homicide detective with Denver Police Department. During her testimony, she will walk you through the whereabouts of Miss Becker on the day the murder took place based on her cell phone records. You will also hear from Kyle Kuzak, who's a certified reconstructive investigator. During her testimony, she will walk you through the procedure of gathering evidence and examining the residence. Lastly, you'll hear from Alex Cifuentes, who's a former teammate of Miss Becker and the one who had previously received the text admitting Miss Becker's plans to break into Mr. Brackman's house while he was at work. After hearing all of this evidence, there will be no reason to hesitate. My co-counsel will ask you to return with a verdict of guilty. Thank you.
Thank you, Madam Prosecutor. I'd like to give just a moment for the scoring panelists, and then we'll proceed to defense open. Okay, defense, whenever you're ready, you may proceed.
Your Honor, opposing counsel, and members of the jury. My name is Jaden Inks, and my co-counsel and I are here today on behalf of our client, the defendant, Avery Becker. This case is as easy as 1, 2, 3. 1. Tragedy. As you heard in the prosecution's opening statement, a beloved coach and well-respected attorney, Mackenzie Brackman, was found dead in his home. We agree with the prosecution on these facts. However, it is where we disagree, which is why we are representing Avery Becker. 2. Tainted. In this investigation done by the police on the prosecution side, our client, Avery Becker, has been accused of murder. Ms. Becker has been charged with first-degree murder and second-degree burglary of a dwelling. These charges are an example of the tainted police work done by the prosecution that is not founded on the truth. Time and again, their investigation was proved to be flawed, and the prosecution's case has too many holes in it, holes that they will not be able to fill. There were missing photos, questionable evidence, and detectives whose work was rushed and sloppy. There were not 1, not 2, but 3 suspects in this case, and they chose Avery Becker. This accusation is another defect of the police's tainted work. 3. Targeted. Avery Becker joined mock trial her freshman year and was looking forward to her senior year on the team. Avery was excited to potentially win awards, and even though she was excellent at what she did, her and her coach often butted heads about her preparation techniques. During a regional competition in early 2020, Avery won the Best Attorney Award as well as Best Closing Argument. But instead of being congratulated for all of her achievements, her coach criticized her, and Avery understandably was upset at this. She showed natural ability and often came through and provided her team with winning experience, especially at their regional competition. Understandably upset, after practice, Avery stormed out and made an impulsive decision. Avery, with what she thought was an erasable marker, wrote across the hood of her coach's car, Worst Attorney Award. As a result of seeing this, Coach Brackman kicked Avery off of the team. And in realizing what she had done, Avery felt immediate remorse and tried to apologize and tried to work over the summer to get the damages paid off. But her attempts were not met by her coach. Today, the defense will put forward not 1, not 2, but 3 witnesses who will show you how Avery Becker did not commit this crime, how she couldn't have committed this crime, and will also point out to you the holes in the prosecution's case and the tainted police work. This case is as easy as 1, 2, 3. 1. Professor Van Owen will walk you through her expertise in crime scene reconstruction and police procedures and offer you an alternate theory and shine light on an alternate suspect. 2. Taylor Perkins. Taylor Perkins, with her knowledge of Avery Becker as a friend, a peer, and a classmate, will tell you how she was with Avery on the day of the murder, March 6th, all day looking for Avery's lost phone. And 3, the defendant herself, Avery Becker, who will testify how she couldn't have committed this crime following the tragic death of her mock trial coach, and how she would never have committed this crime. Today, the prosecution carries the burden of proof, a burden that they will not be able to meet because of the holes within their case. This case is as easy as 1, 2, 3. Today, we will ask you, the jury, at the end of this case, to return a verdict of not guilty of Avery Becker. This case is as easy as 1, 2, 3. And as you will see, Avery Becker is not guilty. Thank you.
Okay, again, I'll give just a moment for the scoring judges. Thank you, timekeepers. I've been seeing updates. It looks like we're in pretty good agreement. So thank you for doing that. Prosecution, are you ready to call your first witness?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
All right. I'm going to, switch my view just 1 second. All right, you may proceed whenever you're ready. As I recall, the competition rules state all witnesses have been sworn in previously.
And Your Honor, before I begin, can you see and hear me okay?
I can, thank you, sir.
At any point, should those conditions change, please do not hesitate to let me know so I can identify and fix the problem.
Certainly.
May I proceed?
Please.
Good afternoon, Detective. Could you please introduce yourself to the jury?
Good afternoon. My name is Detective Jordan Markowitz.
And Detective Markowitz, what is your role in today's case?
I was the lead investigator assigned to the murder of Mackenzie Brackman.
What education or experience did you receive to become a detective in the first place?
Well, I've spent 13 years with the Denver Police Department, 7 of which I've been a homicide investigator. I also received specialized training in the topic of cell phones.
And what kind of education do you have in regards to cell phones?
Well, I'm certified in the collection of cell tower data, cell phone data, forensic data from cell phones, and the analysis of all 3 of those.
And how often would you say that you use that certain area of expertise?
It comes up almost constantly.
Your Honor, at this time, I ask that Detective Jordan Markowitz be recognized as an expert in the field of homicide investigation with an emphasis on cellular phone technology.
Sorry, I'm just making a note of the specific tenders. Homicide investigation with a specific emphasis in cell phone technology. Is that what you said?
Yes, Your Honor.
Defense, any response?
Your Honor, at this time, I have no objection to this witness being qualified as an expert in homicide investigation with an emphasis on cell phone technology, provided that the witness stays within the confines of that expert testimony.
Okay, I agree. The rule for expertise is a low bar. Detective, you are qualified as an expert in homicide investigations with an emphasis in cell phone technology. You may proceed, sir.
Yes, Your Honor. Now, focusing on the case, Detective, when did you arrive at the scene of the crime?
I arrived at the scene of the crime at approximately 14:20 or 2:20 p.m.
And what were your first impressions of the crime scene?
Well, I immediately noticed that the victim had a Ring doorbell system installed in their house and that they were laying partially inside and partially out of their house in a pool of blood.
You have just mentioned a Ring doorbell system. Were there any other cameras found around the residence of the victim?
Yes, there were 3 total, 1 pointing towards the front door, 1 to the back gate, and 1 towards the back door.
And was anything downloaded from these cameras later in your investigation?
Yes, there were 4 videos downloaded.
And what exactly was that footage able to reveal?
Well, the footage shows a masked intruder attempting to enter the front door of Mackenzie Brackman's residence. The others show them entering through the back gate, approaching the back door, and entering through the back door. One of them also shows the intruder leaving through the previously locked front door.
And Detective, in respects to your specialized knowledge in cellular phone technology, did you ever acquire the victim's phone?
Yes, I did. I did search Mr. Brackman's phone.
And what kind of information were you able to derive from his phone?
Well, I got the videos from his phone, but additionally, I found an extensive amount of emails and text messages relating to mock trial, which gave me a big lead in my case.
And what exactly did you do with this mock trial program?
I contacted the school that the victim had previously coached for to obtain student records. I then called a few students in to get interviews with them.
And who did you contact?
One of my contacts was Alex Cifuentes. They gave me some information on another student, which led to a large break in my case.
Was Ms. Cifuentes ever brought in to discuss this great break with you?
Yes, I did bring Alex Cifuentes in for an interview.
And what kind of information were you able to derive from that interview?
Ms. Cifuentes directed me to another student who had previously been on the team, Avery Becker. They were told to have a rocky relationship with Mr. Brackman, the former coach, and even specified their intent to break into and vandalize Mr. Brackman's home.
Objection, Your Honor. Ultimate issue.
Response?
Your Honor, I'm not asking the witness to speak about the ultimate issue. I'm simply asking them to discuss what they did with the information that was obtained through the interview with Alex Fuentes.
Your Honor, if I may have a moment.
I'd just like to follow up. So, Mr. Hernandez, the detective's statement didn't ultimately get to that ultimate issue, is what you're saying?
Yes, Your Honor.
Okay. Last word.
Your Honor, pursuant to 704B, this witness is providing an expert opinion and using that to say intent. And that's my main issue with this question, is that they're saying that this person had intent, and that is against evidentiary rule 704B, which is the exception that they are not allowed to testify on anything that could be intent or state of mind.
Yeah, I tend to agree with defense on this one. It did feel like that statement went a little far. If you would re-ask your question, and detective, I'll instruct you to avoid answering the question thusly. Jury, you are not to consider the detective's former answer, and it shall be stricken from the record.
Thank you, Your Honor.
Please proceed.
Yes, Your Honor. Again, detective, what kind of information were you able to derive from the interview with Alex Fuentes?
Alex Fuentes gave me some information about another student, Avery Becker, who had previously been on the mock trial team. They also gave me a series of text messages between themselves and the defendant.
Your Honor, at this time, I ask that my trial technician be allowed to display their screen to show Exhibit 14 for purposes of identification.
Please do.
Ms. Mintz.
I'm going to ask the timekeeper. Okay, never mind.
Exhibit 14, Ms. Mintz.
Yeah, during this moment, please pause the time. Please resume the time. You may continue, sir.
Yes, Your Honor. Detective, do you recognize this exhibit?
Yes, these are the text messages given to me by Alex Fuentes.
And is it accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I ask that Exhibit 14 be admitted into evidence.
Defense?
Your Honor, I object on the grounds of hearsay and best evidence.
All right. How do you respond to hearsay first?
Your Honor, in pursuant to Rule 801D2, the statements offered in gray are the statements of a party opponent, specifically the defendant, as the Avery Becker is the contact that is being contacted with in this exhibit. And the statements made in green by Alex Fuentes are merely being offered for context to the statements of Ms. Becker.
Okay. And then as to best evidence rule?
Your Honor, in pursuant to Rule 1002, a witness can weigh any best evidence issue so long as they are sure that the copy is given, so long as a witness has knowledge that this is an accurate depiction of the original, it is the best evidence. And as Detective Markowitz has spoken to the fact that she spoke to Missy Fuentes on the matter, she does in fact have knowledge of this document and is therefore making it the best evidence.
Thank you. Defense, can I hear your response first to the text in gray being party opponent?
I have no objection on the party opponent with the gray. However, I do take issue with the green text as being from Alex Fuentes. Certain texts here, especially, I believe it would be, especially statements about a car. The jury has not seen those, and that's being offered for the truth of the matter asserted. And similarly, most of these are being offered for the truth of the matter asserted, and I ask that those statements be redacted on this document if you are going to enter them in, and these are not being offered for the effect on the listener. Would you like me to respond on that best evidence objection as well?
I disagree with your best evidence objection, so I'm going to consider the hearsay objection for just a second. I tend to agree, Mr. Prosecutor, that there's probably some language in here that needs to go beyond effect on the listener. Is it possible to use these text messages in a redacted form, or is there an inherent problem with that?
No, Your Honor, I take no issue with that.
Okay, so then we're going to constructively redact the green text out of these exhibits prior to them being admitted, if that's going to be the prosecution's request.
Your
Yeah, sure.
Honor, if we are redacting all of the green text messages, if I would have an issue with entering the entirety of the exhibit, as then we are now losing the context, and I'd have to expand my objection on prejudice over probative, as we have now lost that context, which, as the hearsay would prevent, I guess, give the context. If we're removing that hearsay statement, we would then lose the context of the conversation, and therefore we would be prejudicing the jury over the probative value of this exhibit.
I understand what you're saying, sir, but I'm going to disagree because it is party opponent. I believe that this is not subject to an objection for hearsay. I know you were trying to get at a 403 objection, but I think that there is probative value in these text messages, independent of the green messages. So we will constructively redact the green messages.
Yes, Your Honor. May I proceed?
Mr. Prosecutor, please proceed.
Detective Markowitz, what exactly is Exhibit 14 able to display to the jury?
Exhibit 14 displays the gray text of Avery Becker talking to what has been redacted as Alex Fuentes about attempting to rejoin the mock trial team.
Thank you, Ms. Spence. That is all. And now, Detective, having knowledge of the defendant, how did you proceed with your investigation?
Well, I attempted to contact the defendant in order to secure an interview, but I was denied an interview and given the defendant's phone number in order to track their phone and find their side of the messages.
And with the defendant's phone gone, how exactly were you able to proceed?
Well, I was informed that the defendant had indeed lost their phone on May 5th, and I proceeded by contacting their service provider and obtaining their call detail records to see the phone's activity on March 6th.
Detective, could you give the jury a short description of what exactly a call detail record is?
Of course. Call detail records are cell towers that show a phone's location when it connected to that tower. They connect to cell towers in order to pass through a text or a call.
Your Honor, at this time, I ask that my trial technician be allowed to display their screen to show Exhibits 15 and 16 for purposes of identification.
Please.
Detective, do you recognize Exhibit 15?
Yes, Exhibit 15 is a map with the cell towers located on there.
And Ms. Mintz, if you could display Exhibit 16. Do you recognize this one, Miss Detective Jordan Markowitz?
Yes, Exhibit 16 is largely the same with the addition of the most likely path Avery Becker took to get from their house to Mr. Beckman's house during the times their phone connected to the towers.
Detective, I apologize. Would you please repeat your answer? It came through pretty gargled.
Of course. Exhibit 16 is largely the same as Exhibit 15, but it's
Your Honor,
it
appears that my witness is having technical difficulties. I would ask that he stopped as those reported out.
Let's pause the clock for a second. Detective, let's try to troubleshoot your Wi-Fi real quick. What's going on?
I don't know if you can hear me right now, but I don't appear to have any issues on my end. I can attempt to turn off my camera and see if that will help.
Is there an objection from the defense to detective testifying not in view that isn't a Sixth Amendment objection?
Your Honor, I think it's just very important for the jury to see the witness to judge their credibility as well from their body language as well as their reactions from the question. So I think I would have to object and make sure that the witness isn't being able to seen by the jury and being evaluated for their credibility.
Yeah, I think that's a fair point. Okay, Detective, can you try talking again and we'll see if we can hear you?
Of course. I'm not sure what else I could do to fix my sound issues. I don't
Is the
believe
courtroom
I'm having
monitor
any
still
issues hearing
present?
you guys.
I'm here. You want to try and log out and log back in and see if that fixes it?
Me?
Yeah.
All right, I'll try it.
And Ms. Mintz, as Detective Markowitz is getting back into the meeting, you may stop sharing your screen.
Man, I thought I was doing good. I've made it to this round without anyone having any technical issues.
Just my luck, I suppose.
Okay, let's see. Let her back in. Let's see if it helps. Oh, now we can't hear you at all.
Try again.
Leave again.
And we got some sound, but it's definitely lagging still.
Hey, Paige, in the chat, do you have your cell phone with you?
It's on the table.
In the chat, there's a way to call in. Go to your microphone where it says mute and choose phone audio, switch to phone audio, and then there's a phone number in the chat to call into. So just leave your video on and then have your phone do the audio. Okay, I'll put it in. Let me give it to you again.
Welcome to Zoom. Enter your meeting ID followed by pound.
You can hear the Zoom lady just fine.
Yeah. Go ahead, try and talk again. Yeah, it does sound a lot better.
Shut up.
I propose we try and continue, and if it's a problem, you can call back in. Does that work for you, ma'am?
That works perfectly. Thank you so much, Your Honor.
All right. So before we start the clock, let's get the exhibit that we were looking up back up, and we'll resume with the detective. Actually, Mr. Hernandez, let's have you re-ask the question, and then detective, you can resupply the answer.
Yes, Your Honor. May I proceed?
Please do.
Ms. Mintz, if you could turn to Exhibit 16. Detective Markowitz, do you recognize Exhibit 16?
I do. Exhibit 16 is largely the same as Exhibit 15, with the addition of the most likely path that Avery Becker's phone took on the day of the murders.
Your Honor, I was able to interpret that answer. If you would like her to respond.
I was able to understand it. Defense, were you able to understand her answer?
I was, Your Honor.
Okay, then please proceed.
Now, Detective, are both of these exhibits accurate to the best of your knowledge?
Yes, they are.
Your Honor, at this time, I ask that Exhibits 15 and 16 be admitted into evidence.
Any objection from defense?
None at this time, Your Honor.
They shall be admitted. Are you asking that they be published?
Yes, Your Honor.
Both are published to the jury.
Now, Detective, turning to Exhibit 15, what is this able to reveal to the jury?
Exhibit 15 shows the 3 cell towers that Avery Becker's phone contacted on March 6th. It also shows the general geographic location of that phone.
And turning to Exhibit 16, what does this reveal?
Exhibit 16 is largely the same, with the same 3 cell towers. However, Exhibit 16 has the addition of the route from Avery Becker's house that they most likely took to reach Mr. Brackman's house when their phone was connected to these towers.
Thank you, Ms. Mintz. You may now stop sharing your screen. Now, Detective, with the evidence that you have mentioned here in court today, and the rest that you accounted for in your investigation, who does it all point to?
The evidence pointed me to Avery Becker.
Thank you, Your Honor. No further questions.
I'm sorry, cross-examination.
Yes, Your Honor. Detective, once you arrived at the crime scene, you took photos with your team. Is that right?
Yes.
Your Honor, at this time, permission to show the witness what has been marked as exhibits 1, 4, 5, and 6.
Please do.
And Detective, these are the photos that you and your team took, are they not?
They are.
And are these fair and accurate representations of what your team saw?
Yes, they are.
Your Honor, I move for the admittance of exhibits 1, 4, 5, and 6.
Any objection?
Your Honor, I would object more prejudicial than probative pursuant to Rule 403, as they all show pictures of Mr. Brackman in his state of death, and as such can be used to sway the jury towards the defense's side of the theory.
Can you elaborate just a little further? In what way do you believe that evidence showing a decedent in a murder case is more prejudicial than probative?
Yes, Your Honor. As the defendant is being laid across, feelings of sympathy may be stretched to the defendant to the victim, excuse me, as the defendant could have done this and is going to be swaying the overall emotion of the jury.
Okay, I guess response from the defense.
Your Honor, I'm going to have to disagree with opposing counsel's prejudice, and I will also make an offer of proof of probative, as this is cross-examination, and this is looking for credibility of not only the investigation, but also the evidence that was provided in this investigation when coming to the expert witness, Jordan Markowitz's opinion.
Yeah, I guess the only thing I would ask you to do is just lay foundation that Detective Markowitz has actually seen these photographs, but I guess you did, I'm sorry. So yeah, they're admitted over the prosecution's objection. They're absolutely probative, as again, they show the decedent and the presumed murder weapon in a murder case. So they're definitely probative.
Your Honor, at this time, I move to publish to the jury.
They shall be published.
Now, Detective, let's look at Exhibit 1 for me, please. And I'm going to have my co-counsel zoom in near his right hand. Are you able to see that right hand?
Yes, I am.
And that right hand is directly above Mackenzie Brockman's head, is it not?
It
Now
is,
let's
yes.
go. Sorry. Now let's go to Exhibit 4 for me, please. And we're going to go to roughly the same around areas. We're going to zoom in up here. Can you see his right hand?
Yes, I can.
And that right hand is to the right of his head.
It is.
It is not in the original area as in Exhibit 1.
No, it is not.
So that hand moved between Exhibit 1 and Exhibit 4.
It did, yes.
Now let's move to Exhibit 5. And we're going to zoom in on the logo on this knife. Are you able to see the letters O, R, and Y and roughly the logo?
I cannot, but that may just be because of my screen's blurriness. I'll take your word for it.
Okay, and those letters O, R, and Y are not covered in blood on this knife, right?
They do not appear to be, no.
Now let's move over to exhibit number 6. And exhibit number 6 is the same exact knife from the crime scene, except taken at your laboratory, right?
Yes, it is.
Now let's zoom into that logo area again. The letters O, R, and Y are not on this knife.
It appears to be an issue of glare, but they do not appear there, no.
In fact, none of the lettering from the knife in exhibit 5 are on this knife.
It appears to me that it's an issue with the lighting, but no, they do not appear.
So one could agree that this is not the same knife.
No, I cannot agree to that.
Now let's move on to the call detail records that you examined, and we're going to go to exhibit number 15. We're going to look at how you compiled this diagram. Your Honor, if I may just have a moment for my co-counsel to pull up exhibit 15.
Yeah, we'll go ahead and pause for just a second on the time, because I did for the prosecution to pull up an exhibit. Go ahead.
Now we're going to zoom into the forwardmost tower over here. And you have 2 marked locations on this map, right?
Yes.
Including one location titled Roland's house.
Yes.
And you never investigated Blair Roland's.
We investigated initially, but there simply wasn't enough evidence to back them as a suspect.
But there was enough evidence to place their house on the map.
There was. And that's where the evidence
And
ended.
you testified about the most ideal route from my client's house to Mackenzie Brockman's house, right?
Yes, I did.
Most likely along Rock Creek Parkway.
Yes.
And you would agree with me that Blair Rowland's house is roughly very close to Avery Becker's house.
It's in the same area.
And since they're in the same area, wouldn't you agree with me that the same route that Rowland's would have taken is Rock Creek Parkway?
I could agree with that, but that's not what happened.
Now, let's talk about the nature of call detail records. Call detail records are only an approximation of a cell phone's location.
Yes, they are.
And you can't accurately pinpoint the exact location of the cell phone.
It's not a pinpoint, no.
And on occasion, a cell phone will ping to a farther away tower if the nearer tower is busy or too complicated.
Yes.
And you could agree with me that a cell phone could connect in those circumstances to a farther away cell phone.
It could, yes. It would connect to a tower, not a phone, sorry.
For example, Avery Becker's cell phone could have connected to a farther tower closer to Mackenzie Brockman's home if it was farther away.
Potentially, but it's unlikely.
And call detail records don't actually guarantee where the person is with their cell phone.
Objection, Your Honor, asked and answered.
Response?
Your Honor, I haven't asked about the location of a person with their cell phone, and I never asked or gone into this territory on cross-examination yet.
Response?
Your Honor, defense has already solicited that nowhere can a phone be pinpointed in this exhibit, and as such is the same scenario with a person with their phone.
I agree it's a similar scenario, but I think in this case it's different enough that I'm going to allow him to ask the question. Thank you for your objection.
Yes, Your Honor.
Now, Ms. Detective, a cell phone does, the CDR records do not indicate that a person was with their cell phone, correct?
No.
It cannot guarantee that someone was at the location of the cell phone compared to their cell phone.
I'm not sure what you mean.
That a call detail record cannot confirm that a person was with their phone in respects to their cell phone.
No.
Meaning you don't have definitive proof that my client was with her cell phone.
No, we do not.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor, a brief one.
Okay.
Can I proceed?
Please do.
Detective, in preparation for this investigation, how much validity did you give to the exhibits you reviewed in your investigation?
They were all considered equally.
And how significant were each piece of those evidence? And how significant was each part of those evidence?
Each piece of evidence drew me closer to the same conclusion.
Thank you, Your Honor. No further questions.
I'm not going to allow a recross on that because I don't feel it straight into new territory. May this witness be excused?
Yes, Your Honor.
Okay. I'll give just a second for scoring panelists to get caught up. I realized I kind of rushed from the last couple, so we'll take just a second here. Alrighty, prosecution, you may call your next witness.
Your Honor, the prosecution calls Alex Fuentes to the stand.
All right, you're sworn in. Please proceed.
Before we both begin, can you hear and see both of us?
I apologize, Miss Rangel, is it? Can you speak?
Yes, sorry. Hi.
Okay, I can hear you. Perfect. Please proceed.
Good afternoon. Please introduce yourself to the jury.
Hi, my name is Alex Fuentes.
Ms. Fuentes, could you please explain how you're connected to this case today?
Avery and I were both on the Colorado High mock trial team.
And how long have you been on the team together?
We both joined freshman year. Actually, it was Avery who got me into joining the team.
So how would you describe your relationship with Ms. Becker?
We never really saw eye to eye in mock trial. Avery lacked commitment towards the team, and she was never prepared for tournaments and practices. I take mock trial very seriously. I'm always reading the case, getting on my direct and cross examinations, right when Coach Braxman assigns them, and well, Avery doesn't.
Let's pause the timer for just a second. Can you take care of your dog very quickly, please? Okay, you may proceed whenever you're ready. Timers, thank you.
Sorry.
Sorry.
Excuse me. And Ms. Cifuentes, how would you describe your time on mock trial?
Like I said, I take mock trial very seriously and try to succeed. And Avery succeeds without trying as hard as the other members, which always made Coach Brackman mad.
On that note, would you please describe Avery and your former coach's relationship?
Yes, Avery and Coach Brackman
Objection,
never
Your
got
Honor.
along.
Lack of personal knowledge.
Response?
Your Honor, this witness has testified to being on a team with Ms. Becker for over 3 years and therefore has personal knowledge of their relationship as they were with their coach for all 3 years also.
Response?
May I add to my objection?
You may.
Based off of counsel's response, I also believe that this then is speculation, as this witness cannot testify to how Avery Becker's relationship was with her coaches. She was not Coach Mackenzie Brackman or Avery Becker.
Thank you for your objection, both of them. I am going to overrule the objection. I think as long as the witness states in her personal knowledge of the relationship, that it is acceptable. You may proceed.
Ms. Fuentes, did you get the chance to finish your answer?
No, I did not.
Could you please describe Avery and your former coach's relationship?
Yes, Avery and Coach Brackman never got along. They always argued about Avery's lack of commitment towards the team and how she is never prepared for tournaments, as I said, and practices. Things got worse after the incident with Coach Brackman's car.
And what happened at practice before this incident?
We had a competition the weekend before, and Avery had won the Best Attorney Award. And she and Coach Brackman got into an argument about how she shouldn't be confusing good showsmanship with good lawyering and saying stuff like she really didn't deserve that award.
And to the best of your abilities, could you please explain the incident with your coach's car more in detail?
After practice, we usually write our ideas down while leaving. I saw Avery grab a permanent marker. She vandalized Coach Brackman's car, writing Worst Attorney Award across his hood of his beloved car.
And how did the victim react to this?
Well, first was kicked off the team, and she later on texted me asking if I could talk to Coach Brackman about letting her back on the team.
Your Honor, at this time, I ask that our trial technician please pull up Exhibit 14, which has previously been admitted into evidence.
You may do so.
Ms. Cifuentes, only referencing the text in gray, could you please explain what these are?
Yes, these are the messages Avery sent to me asking if I could talk to Coach Brackman about letting her back on the team.
And did you talk to the victim?
Yes, I did. But he wasn't interested in letting her back on the team. Avery wasn't committed to mock trial, so why would she get back on the team? It doesn't make any sense.
After talking to your coach, did you talk to Miss Becker again?
Yes, I told her that he wasn't interested, and Avery seemed really desperate to get back on the team. And she later on texted me saying that what she did to Coach Brackman's car was nothing.
And did Miss Becker say anything else about what she was planning?
I didn't know what to say, so I asked her what she meant by that. And she later on texted me saying that she was going to break in
Objection,
and
Your
trash
Honor,
his house.
cumulative.
All right. Response to cumulative.
I'm sorry, Your Honor. I seem to have glitched out. May she please reiterate her
The
objection?
objection is to cumulative, that the witness's answer was cumulative.
Your Honor, this question is referring to two different pieces of evidence in Exhibit 14 and therefore is not cumulative.
May I respond, Your Honor?
You may.
Just as co-counsel said, she is having her witness refer directly to this piece of evidence twice over, reading directly from the messages. And I think that this is a waste of the jury's time, as it has been fully admitted to the jury. They have copies of this document. They are able to read it for themselves. I do not believe that we need the witness to reiterate these statements.
Okay, thank you. I guess technically I'm going to sustain the objection. Madam Prosecutor, you can continue on a similar line of questioning, but having the witness read from the exhibit itself is a little bit cumulative in my opinion. So I would ask you not to have the witness read something that the jury is able to read themselves.
Yes, Your Honor. After telling Miss Becker what happened, was that the last you heard from her?
Yes, after that, she did text me again, and we all went our ways after the incident.
Moving on, after the incident, you met up with Detective Markowitz, correct?
Yes, that's correct.
Let's talk about your interview with Detective Markowitz. Did you share these messages?
Yes, I had mentioned the messages to Detective Markowitz, but I didn't have my phone on me. So she asked if I could send her screenshots of the messages when I got home.
Thank you, Ms. Mintz. You can take down the exhibit. And why didn't you have your phone with you?
Honestly, it was a pretty old phone and didn't stay charged for so long, so I just forgot to grab it on the way out the door.
And when you got home from the interview, did you send the screenshots of your messages?
Yes, I sent the screenshots of the messages to Detective Markowitz and asked if there was anything else she needed, but after that, didn't hear too much from Detective Markowitz again.
And why didn't you turn your phone into the police?
My parents offered to bring the phone to the station the next day, but I guess it wasn't necessary.
Ms. Cifuentes, after your brief conversation with the defendant containing Ms. Becker's words, break in and trash and gray.
Objection, Your Honor, cumulative.
Response?
Your Honor, again, I am just trying to this is two different pieces of evidence that are being referenced and is therefore not cumulative. Ms. Cifuentes has not referred to these mere words before in her testimony.
Okay. Hold on just 1 second. I'm sorry. Would you mind, the question got cut off, so I didn't hear it entirely. Would you mind repeating just the start of your question up until the point that counsel objected?
I do not remember exactly where objected. I can go to a rough area.
Sure.
Okay. Ms. Cifuentes, after your brief conversation with the defendant containing Ms. Becker's words, break in and trash and gray, do you believe?
So then your objection is to specifically the inclusion of her verbatim words. Is that your objection?
Verbatim, yes, verbatim stating from the exact exhibit like she mentioned.
Yeah, I disagree this time. I don't think it's cumulative this time. I think the way that she has worked it around is appropriate. I'll allow you to re-ask the question in its entirety, Ms. Cifuentes, you may respond. Thank you for your objection.
May I repeat the question because I've still not been able to do the whole thing?
Yeah, please do.
Thank you. Ms. Cifuentes, after your brief conversation with the defendant containing Ms. Becker's words, break in and trash and gray, do you believe Ms. Becker was angry enough to the best of your abilities with your former coach to make a rash decision?
Avery definitely had a lot of mixed emotions. but after
Objection,
the
Your Honor.
coincidence-
Speculation.
I guess I'll ask the prosecutor to provide foundation that the witness knows this statement before she makes it. So I will sustain the objection. If you could just find a little bit of foundation as to how this witness would know what you're going to ask.
Ms. Fuentes, to the best of your abilities, after Mr. Brackman kicked Miss Becker off the team, was she angry with your former coach?
Yes, she was really angry.
Therefore, do you believe Miss Becker was angry enough with your former coach to make a rash decision?
Avery was definitely really angry, and after the car incident with Coach Brackman's car, I wouldn't put it past her if she had made a reckless decision.
Thank you, Your Honor. No further questions.
Okay, I'm going to take just a moment before I allow cross-examination for the scoring panelists. All right, cross-examination,
Yes, Your Honor.
please proceed.
Ms. Fuentes, you know our client, Avery Becker.
Yes, I do.
You have always been really good friends with Avery Becker.
Yes, Avery and I were really close.
The two of you have been on the same mock trial team since your freshman year.
Yes,
And you consider Avery to be an equal.
yes.
Yet you considered yourself to work harder than her.
Yeah, she didn't put in enough work for our team, so I
You
worked a lot
even,
harder.
my bad, please finish your response.
Oh, I was finishing. It's okay.
Okay. You even admit to being upset at Avery for coming in unprepared, yet winning all of the awards.
Yes, she was unprepared, so I didn't think she really deserved that award.
You saw Avery winning awards at all of your competitions,
Yes, she won
And-
plenty of awards.
and this upset you.
Yeah, she didn't work hard. It upset me and the team.
Because it should be you winning the awards.
People that worked hard, yes.
In fact, there were multiple instances where you were jealous of Avery's success.
Jealous? Yeah, I guess you can say that, but she didn't really work hard.
And thought she was lazy and not a hard worker.
She didn't work hard, yes.
Were you present when Miss Becker vandalized Mackenzie Brackman's car?
No, I was not.
However, this incident did result in Avery being permanently kicked off of the team.
Yes, she grabbed a permanent marker and vandalized his car.
Avery's punishment put your team in a really hard place.
Yes, we couldn't compete due to mock trial rules.
And many of you were extremely upset at her.
Yes, we couldn't compete, even though we worked really hard to get to where we were.
It was common knowledge on your team that you and Avery were considered to be rivals.
Yes, everyone thought we were rivals.
Yet you wholeheartedly disagree with this statement.
Yes.
You spent a lot of time honing your craft.
I'm sorry, I do not understand your question. Can you rephrase it?
You spent a lot of time putting work into your mock trial duties, your abilities as an attorney on your mock trial team.
Yes, I worked really hard.
You were upset when Avery came in and won all of the awards without doing anything.
Yes, the team and I, because she was unprepared.
You think that the only way that Avery ever won her awards was only based off of her looks.
Yes.
And you weren't rivals, but you thought the team would be better off without Avery.
She wasn't prepared, nor she would come to practices on time. So I don't think it would make a difference if she was or wasn't there.
And you weren't rivals, but you were excited to have a higher place on the team, knowing that Avery would be on.
I was excited. Everyone else was too.
Moving on, I'd now like to direct your attention towards your role in the police's investigation. You were at the Fry Shack the night before the murder and school the next day.
Yes.
It is your statement here that you were at school the next day.
Yes.
Your Honor, permission to show the witness what has been marked as their affidavit.
For purpose of impeachment,
Yes, Your Honor.
please do.
Ms. Cifuentes, is this your affidavit?
Yes.
And at the bottom, which my co-counsel is getting at, is that your signature at the bottom?
Yes, it is.
And you were aware that you have had time since you written this affidavit to update it with any current information before today's trial?
Yes.
And anywhere in this affidavit, you do not say, I was at school the next day.
No.
Thank you. Moving on. So you have no alibi putting you anywhere the day of the crime.
No.
Moving on. Detective Markowitz asked you to bring in your cell phone to the police station for an interview
Yes.
because you indicated that there were text messages between you and Avery concerning Coach Brackman.
Yes.
However, you failed to bring in your phone to the interview.
I forgot it at
So
my
the
house.
Sorry. So the police never had an opportunity to look at the text messages off of your phone.
No, they did not.
And you were asked to send in some screenshots.
Yes, by Detective Markowitz.
And Exhibit 14 is an accurate depiction of those same screenshots.
Yes.
And it is in these messages that Avery asks for your help to convince Coach Brackman to let her back on the team.
Yes.
And you said that you would try.
Yes, and I did.
And in fact, you did approach Coach Brackman and made an impassioned plea on behalf of Avery Becker.
Yes.
And then you texted Avery saying that Brackman was not going to back down.
Yes.
And that statement claiming that Brackman was not going to back down is nowhere included in Exhibit 14.
Well, he wasn't interested.
So Exhibit 14 does not reflect all of the text messages sent between you and the defendant, Avery Becker.
No.
Thank you, Your Honor. No further questions.
I'm sorry, I'd like to clarify the witness's last answer. So would you mind repeating your question? It just got a little jumbled and I thought I heard a nod and a no, so I want to make sure I understand the answer.
Yes, Your Honor. So Exhibit 14 does not reflect all of the text messages sent between you and Avery Becker.
No.
Thank you, Your Honor. No further questions.
Okay, and my apologies that the technology error is kind of difficult. Madam Prosecutor, redirect,
Briefly, Your Honor.
please.
Ms. Cifuentes, during your conversation with Ms. Becker, is there any text that you deleted?
No.
And are there any texts you did not include in these screenshots?
There is not.
Therefore, Exhibit 14 is an accurate representation.
Objection, Your Honor. Leading questions on redirect examination.
I would ask for a response. Do you think you were leading?
No, Your Honor. I am simply trying to clarify the witness's last response on cross-examination.
I agree that you're trying to clarify. Just make sure that you ask an open-ended question. So again, technically the objection is sustained. I think you were leading a little bit, but I think you can ask the same question open-ended.
Yes, Your Honor. Ms. Cifuentes, in your opinion, Is Exhibit 14 an accurate representation of your conversation with Miss Becker?
Yes, it is an accurate screenshot.
And are there any text messages left out?
Objection,
No, there
Your
is
Honor.
not.
Leading question, as she has continued to leave questions at a not open-ended that calls and insinuates an answer. I believe that she continues to lead on redirect.
Yeah, I understand your objection. I'm going to overrule it on that one. I think the question was a fair yes or no question.
Ms. Fuentes, are there any messages in Exhibit 14 missing?
No, there isn't.
No further questions.
I would consider a brief recross if you asked for one.
May I, Your Honor?
Very brief, please.
These messages that you have between you and Avery Becker were never shown to the police.
No, I did not have my phone on me, and my parents bought me a new one.
You never showed them directly off your phone.
No.
They never pulled this information directly off of your phone.
No.
So you sent in screenshots
Yes.
that you easily could have doctored,
I would never do that.
that do not provide accurate information showing the complete conversation between you and Avery Becker.
No.
Thank you, Your Honor. No further questions.
May this witness be excused?
Yes, Your Honor.
Alrighty, again, I'll give just a moment for scoring panelists to get caught up. And again, timekeepers, I haven't seen any major discrepancies between the time. If there is any discrepancy, please let me know. All right, prosecution, you may call your next witness.
Your Honor, the prosecution calls Kyle Kuzak to the stand. Your Honor,
Sorry, go ahead.
Before I begin, may I inquire as to how much time I have remaining?
Timekeeper.
You have 8 minutes and 3 seconds remaining.
Allow me one moment while I adjust my camera.
Okay, and witness, you are constructively sworn in. Whenever you're ready, Mr. Winton.
Good evening. Could you please introduce yourself to the jury?
Good evening. My name is Kyle Kuzak.
Why are you here today, Ms. Kuzak?
I worked as a crime scene reconstruction investigator, or CSR for short, with the Denver Police Department, and I reconstructed the murder of Mr. Brackman.
Could you explain to us how you obtained this position?
Yes, I have over 19 years of experience with crime scene reconstruction. I've worked on everything from burglaries and home invasion to domestic violence and homicide.
Your Honor, at this time, I ask that Ms. Kuzak be tendered as an expert in the field of crime scene reconstruction.
Okay, any objection to crime scene reconstruction as the field of expertise?
No objection at this time.
No.
Oh, sorry. No objection at this time, Your Honor. I just ask that the witness stay within her scope of her expertise.
And of course, if you feel that she's straying, you're more than welcome to object. The witness shall be tendered as an expert in crime scene reconstruction. You may continue, sir.
Ms. Kuzak, could you walk us through how you prepare for a reconstruction?
Of course, I work under a 5-step process: recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and finally reconstruction.
Could you break this process down a little bit more for us?
Absolutely. Most of my process, I'm told, is very boring, but I love it. Mostly I'm collecting, organizing, and analyzing the evidence I have access to. I find that spreadsheets and flowcharts are especially helpful when it comes to the organization part of my analysis.
Could you give us more detail about this organization step?
Yes. The first thing I do is I create a witness tracking spreadsheet. This allows me to compare each witness's stories to what the physical evidence says. I then create a flow chart, which helps me then create a timeline. These help me stay very organized and not get lost into too much detail and focus on the big picture.
Could you explain to us what evidence you reviewed in preparation for today's case?
Yes, I reviewed all police reports, photographs, and security cameras.
Now, using what you know about the case, could you explain to us what happened on the day of the break-in?
Yes. On or about March 6, 2020, a person matching the physical description of the defendant, Avery Becker, approached the front porch and attempted to enter through the front door of the victim, Mr. Brackman's residence.
What happened next?
Well, the front door had been locked. So then the intruder went to the south side of the residence, passing a fence gate and approaching the sliding glass door of the residence.
What did they do once they reached this door?
Well, the intruder proceeded into the residence.
Now, could you tell us what the intruder did once they were inside Mr. Brackman's home?
Well, the victim, Mr. Brackman, had been alerted of the intruder and proceeded to grab a knife from a knife drawer, but ended up grabbing a knife from the knife block and went to confront and defend themselves against the intruder.
Your Honor, may my trial technician display Exhibit 8 and 5 for the witness?
Please. Go ahead and do a brief pause of the timer. Okay, go ahead and resume the time and you may continue, sir.
Ms. Kuzak, excuse me, Ms. There. Ms. Kuzak, are these exhibits fair and accurate to the best of your knowledge?
Yes, they are fair and accurate.
Your Honor, at this time, I move to admit exhibits 5 and 8 into evidence.
Okay, any objection?
Yes, Your Honor, I object to the fact that these images have not been identified yet by the witness.
Yeah, I tend to agree, counsel. I think you need to lay a little more foundation before these can be admitted.
Ms. Kuzak, could you tell us a little bit about these exhibits?
Yes, Exhibit A is the knife block that was near the knife drawer in the kitchen of the victim's residence.
And Exhibit 4.
I'm sorry, Your Honor.
I'm sorry, Exhibit 5, please.
And what can you tell us about this exhibit?
This is the knife that was recovered next to the victim's body.
Defense, any objection?
No objection at this time, Your Honor.
All right, sorry, Mr. Prosecutor, what are you asking me to do with these? Admit and publish?
Yes, Your Honor.
They shall be admitted, shall be published.
Ms. Kuzak, what can you tell us about these exhibits? How did they affect your investigation?
Well, with the knife block and the knife, okay, so when the intruder had entered the residence and the victim had gone to confront the intruder, they were engaged in close contact and were engaged in a sort of struggle to obtain the knife that the victim was holding.
Thank you, Ms. Mintz. You may take those exhibits down now. Now, can you give us a little more information about what exactly happened when Mr. Brackman was stabbed?
Mr. Brackman, it is my professional conclusion that when the intruder and the victim were engaged in close contact, the intruder was able to disarm the victim and obtain the knife in its hand, the intruder's hand, and reach over the victim in a bear hug type motion and stab the victim through the shoulder.
Now, are you aware of Professor Van Owen's conclusions in today's case?
Yes, I am.
Do you think there's any validity to her conclusions?
Yes, I do.
You do think there is validity to your conclusions, or you find issue with the conclusions?
I find a couple issues.
Could you point some of these out to the jury?
Well, for starters, unlike what Mr. Van Owen believes, there is clear evidence of a struggle.
Objection, Your Honor. Lack of foundation.
Response.
Your Honor, the witness has testified to have being aware of all evidence in today's case. Therefore, she is aware of the various reports that Professor Van Owen presented as evidence during this case. Therefore, she has plenty of foundation for how she knows and can testify about these.
Mr. Maher.
Your Honor, we have not heard testimony from Blake Van Owen yet, let alone a report from him or her, sorry. We have not seen anything from her, so I believe that this witness should not be allowed to testify about their findings.
Your Honor, may I respond?
No, I understand the problem here. Normally, the prosecution would be able to call this witness as a rebuttal witness. There's no rebuttal witness here. Therefore, I am going to allow the detective or this witness to talk about this report. I do find that it falls within the purview of expert testimony, and that the person did testify that she had reviewed the materials relevant to today's case prior to coming here today. So I'm going to overrule the objection. I'm going to allow the testimony to continue and allow this expert to opine on, I presume, your report.
Yes, Your Honor.
Yes, Your Honor. Ms. Kuzak, could you point out some of the flaws in Professor Van Owen's conclusions?
Absolutely. For starters, unlike what Ms. Van Owen believes, there is clear evidence of a struggle. From the knife drawer, the knife block, the broken plate, and the scuff marks on the floor, there is clear evidence of a struggle.
Thank you, Your Honor. No further questions.
Okay, we'll take just a brief pause to allow the scoring panelists to catch up. All right, defense, whenever you're ready.
Yes, Your Honor. Mrs. Kuzak, you made a witness tracking spreadsheet for this investigation, correct?
Yes, it is one of my very first steps.
Your Honor, may I show the witness what has been marked as Exhibit 17?
Yes.
My co-counsel will be pulling it up. So, there. Do you know what this is?
Yes, it is my witness tracking spreadsheet.
And is this a fair and accurate representation of that witness tracking spreadsheet?
Yes.
And this witness tracking spreadsheet was made during your investigation?
Yes, of course it was.
Made with your knowledge of all the events and all evidence of the case?
Yes, as a CSR I was given, yes.
And this witness tracking spreadsheet is regularly conducted activity for you?
Yes, it is part of my process and part of a CSR process.
At this time, Your Honor, I move to admit Exhibit 17 into evidence and publish to jury.
Any objection?
No objection, Your Honor.
All right, then it will be admitted and published. I think it was Exhibit 16 you said, or 17?
17.
17. It shall be admitted and published as Exhibit 17. Thank you. Proceed.
Let me direct your attention to the first page of your witness tracking spreadsheet. The letter S on this means suspect, correct?
Yes, it means suspect.
And you list not one, not two, but three suspects?
Yes, there were 3 suspects.
They are Avery Becker,
Yes.
Alex Cifuentes,
Yes.
and Blair Rollins.
Yes.
And Alex's name is spelled incorrectly on this document, correct?
Well, I'm not the best with spelling, I would say.
And moving to the crime scene, you investigated it yourself. And counsel, you can take that down, sorry.
Could you re-ask your question?
Yes, I will restate my question. Moving to the crime scene, you investigated there, correct?
Yes, I visited the crime scene.
And you believe that the that the victim was, sorry, you believe that the victim was alerted by his Ring doorbell camera?
Yes, the victim, that's what a Ring security camera does. It alerts you of any harm or damage around your house.
But there is no way to tell for sure that he was alerted by his Ring doorbell camera.
No.
Meaning you don't have evidence of a struggle.
Yes, I do. When the intruder opened the sliding glass door, there were scuff marks. There had been made scuff marks on the floor.
You mentioned scuff marks, but there's no way to tell when they occurred, correct?
Not exactly, but it is very clear evidence that there was a struggle on that day where the scuff marks were made.
So you cannot accurately put a date on when those scuff marks occurred.
No, unfortunately, I cannot.
So you don't have evidence of a struggle.
Yes, I do. Like I said before, the broken plate on the floor.
Moving on, you didn't find any DNA evidence other than the victim's.
Well, as seen as in the videos, the intruder was wearing a disguise that included gloves. So it is obvious that there wouldn't be any DNA or fingerprints left.
Meaning you don't have any DNA evidence.
The only DNA found was the victim, so no.
And the intruder was wearing a mask.
Yes, as I previously stated.
Which means you can't tell who the intruder is.
No.
Or you can't tell the face of the intruder.
No, they were wearing a mask.
You only have a generalized height and build for the intruder.
Yes, it was shown in the video.
Meaning all you have for evidence to put Avery Becker at the scene of the crime is a generalized height and build.
Along with what everything Detective Markowitz talked about.
But you, yourself, only have a generalized height and build to put Avery Becker at the scene of the crime.
Yes.
No further questions at this time, Your Honor.
Okay, redirect.
Yes, Your Honor.
Whenever you're ready.
Ms. Van Owen, in your professional opinion, when were the scuff marks made?
The day of the murder.
Objection, Your Honor. Outside of the scope of her expertise.
Your Honor, may I respond?
You may. I believe the expertise was crime scene reconstruction, so please respond.
Your Honor, being a CSR, Ms. Kuzak is constantly in contact with crime scenes, and her job is to figure out what exactly took place. Part of this is dating various evidence within that crime scene. This would put the dating an approximate time of the scuff marks being made well within her realm of expertise.
Your Honor, if I
Please.
may, I asked on cross if she could do it, and she said that she could not put a date on those exact scuff marks, meaning that it is not within her expertise.
I understand the objection. I think that's something perhaps you could argue at a later point. For now, I'm going to overrule the objection. I'm going to allow you to re-ask the question. I'll allow the witness to answer the question.
In your professional opinion, when were the scuff marks made?
In my professional opinion, the scuff marks were made the day of the murder.
And again, in your professional opinion, is there evidence of a struggle?
In my professional opinion, yes, there was a struggle.
Thank you, Your Honor. No further questions.
Is there a request for a recross?
Yes, Your Honor, very brief.
Very.
It is your testimony here today that you can date those scuff marks?
I cannot, but in my professional opinion and conclusion through this case, the scuff marks were made the day of the murder.
But let me reiterate, you cannot put a date on those scuff marks.
No, I cannot.
And nobody in this investigation did put a date on those scuff marks.
To my knowledge, nobody did.
No further questions at this time, Your Honor.
May this witness be excused?
Yes, Your Honor. And the prosecution rests its case in chief.
Okay, do we have any halftime motions, or are we ready to proceed to the defense case in chief if you choose to put one on?
The defense calls Professor Blake Van Owen to the stand.
Okay. Sorry, Ms. Van Owen, it looks like you are constructively sworn in. If I can't hear, I'll interrupt. Please proceed when you're ready.
Please state your name and spell it for the record.
Blake Van Owen, Van, V-A-N, Owen, O-W-E-N.
And Ms. Van Owen, what is your occupation?
Currently, I work as a private investigator and a professor.
Do you have any other job experience?
Previously, I was employed with the Aurora Police Department. I've also worked as a school resource officer and a private security guard before making my transition to my current occupation as a private investigator.
And what education have you completed in your field?
I first obtained my bachelor's degree from the University of Colorado Boulder in 2005, and then I obtained my master's degree of criminal justice at Ashford University's online program.
And what additional training have you gone through?
My out-of-classroom experience started at the Aurora Police Department as a law enforcement officer. After that, I then taught a class on police procedures at Community College of the Rockies. And for the last 5 years, I've been teaching a class on police practices and social justice at CU Denver.
Have you ever previously testified in court?
I've testified as an expert in a number of U.S. district and state courts in the states of Colorado, Kansas, Arizona, Wyoming, Nebraska, and New Mexico, providing my expert opinion 25 times and consulting in over 100 cases.
And in what fields have you testified to as an expert witness?
I've testified as an expert in 3 areas, I've testified as an expert in 3 areas multiple times, those being crime scene reconstruction 8 times, cell tower data analysis 5 times, and general police practices 12 times.
Your Honor, at this time, we ask that this witness be entered as an expert witness in police procedures with an emphasis on crime scene reconstruction and cell tower analysis as pursuant to Rule 702. They meet the criteria of training, knowledge, and expertise.
Response?
Your Honor, I would object to her being entered as an expert in the field of cell phone data, as she has not testified to having any experience or training. She has merely testified that she has testified in that field previously, but brought no evidence of her training in this court today.
Given that the witness is under oath and has testified that she has been qualified as an expert in the cellular data 5 times, given that 702 is a low bar, I'm going to trust the prior judge's rulings that she is qualified in this case as well. So she shall be tendered as an expert, or qualified, I suppose. She was tendered and will be qualified in police practices with a specific emphasis in crime scene reconstruction and cell data reconstruction. Is that fair for everyone?
Yes, Your Honor.
Yes, Your Honor.
Okay. Proceed.
Professor Van Owen, why are you here in court today?
I'm here to testify on behalf of the defense as someone with knowledge of police practices and my time as a private investigator who has consulted on this particular case.
And how did you get involved with this case?
I was hired to investigate the case on behalf of the defendant, Avery Becker, and the potential holes in the prosecution's case.
What fields were you asked to testify to?
I was asked to give the opinions on 3 things. 1, that Mr. Brackman was not guaranteed to have been stabbed during a struggle. 2, to establish that Avery Becker's phone was not at the crime scene and neither was Avery Becker. And 3, to establish that the prosecution's case is not methodologically sound.
And what materials did you review in order to come to this conclusion?
I reviewed 3 areas: the crime scene investigation, as well as the cell tower data and the police reports.
What are your opinions regarding those police reports given by Detective Markowitz and Kyle Kuzak?
After reviewing the materials provided by Detective Markowitz and Kyle Kuzak, such as the crime scene investigation, the cell tower data, and the police reports, I felt the need to conduct an investigation of my own.
And what was the specific reason for needing to conduct your own personal investigation?
Well, it was rather unfortunate that the materials given to me were haphazardly conducted. And as a result, they missed a lot of important information that I expanded on in my own investigation. You cannot call it evidence if it's solely based on assumptions.
And in your personal investigation, what material did you review?
I covered areas such as the murder weapon, the method of killing, the cell tower data, and investigated the prosecution's overall case.
And in your expert opinion, how was Mr. Brackman most likely killed?
Well, rather than any kind of struggle, it's most likely that Mr. Brackman was killed while sitting down.
And why do you think that that's true?
Well, according to my findings, the position of the knife would have had to have been very specific to have pierced through the scapula and nicked the aorta, which is the cause of death noted. Also, the person who would have had stabbed Brackman would have most likely done so from behind and would have had to have been of a much larger build than Brackman. And if both of these had proved to be true, it would explain how Brackman would have died and what to look for in the murder suspect.
Would it be possible for someone of similar build to have overtaken the victim?
No, the assailant, like I said, would have to have been of a much larger stature than Mr. Brackman to have stabbed him from a downward angle while standing, which is demonstrated in my report. And this all made the possibility of a struggle very uncertain and not likely the scenario.
How would the victim would have had prior notice to it being attacked?
Well, in reality, Mr. Brackman wouldn't have known. I know that there's a possibility of the Ring doorbell giving a notification that could have given Mr. Brackman warning that someone was approaching his residence. However, there's no tangible evidence or records stating that Mr. Brackman had received the notification. So since the prosecution didn't obtain these complete records, this fact cannot be proven true. Well, this cannot be proven a true fact.
I'd now like to talk about some information regarding the cell phone towers in this case. What is the coverage of an average urban cell phone tower?
In an urban area, the average radius is about 6 to 7 miles.
And how can you identify where a phone has been located inside this 6 to 7 mile radius?
Each sector represents an antenna on the cell tower, and by identifying the sector, it's possible to identify where within that sector the phone could have been based on the multiple antennas.
And is this method of location always reliable?
In reality, cell phones don't always connect to the nearest tower. For example, if there's heavier cellular usage at the time, one's phone may connect to a tower that's less busy and further away, so the data is not always precise.
And in your expert opinion, what is the possibility of Avery Becker being within the radius of Mr. Brackman's home according to the cell towers?
Well, if Avery's phone had pinged off of the tower near the victim's home, it's no guarantee that she was herself in the victim's home just because her phone had connected to that tower. There's no way to tell the exact location of Avery to say whether or not that she was in the victim's home.
Could you please, for the jury, review why you conducted your own investigation? What specifically motivated you to do your own research?
Objection asked and answered. Earlier in the direct, the attorney asked a very similar question and elicited the answer of why Ms. Van Owen conducted her own investigation.
Response?
Yeah, as I stated previously, I'm just re-clarifying for the jury, as that was brought up earlier. I have had a lot of questioning, and this is an expert. She's brought up a lot of data, very critical, analytical data since then, and I just want to make sure, going back into this line of questioning, that for the jury, it is outstandingly clear where we are going forward in my questioning.
It sounds like you agree that it's asked and answered. So I'll sustain the objection.
Okay.
I ask that her question be stricken from the record.
It shall be. And jury, please disregard.
Okay. Ms. Van Owen, in your In your own investigation, you mentioned previously that there was incomplete evidence regarding the prosecution's case. What exactly are you referring to?
Well, first, the pictures of the blood drops in the hallway and the cast off near the front door were lost. Apparently, the image files were corrupted. Not only that, but the investigation from the prosecution's witness, Detective Markowitz, on the cell phone tower records, she only obtained the records from a limited window instead of the full, complete day of the murder.
What is your opinion on the screenshots from Alex Cifuentes?
Honestly, I'm extremely surprised that these screenshots were even used in the building of their case. Instead of obtaining the phone itself with the actual messages on it, their investigation accepted screenshots that easily could have been doctored. Obviously, this was a matter of what was convenient to them at the time instead of bringing in actual evidence.
And is this a normal procedure used in policing?
No, it's not. The police have special hardware for this purpose. The Denver police specifically use Celebrite. And if I remember correctly, Detective Markowitz had mentioned how they had downloaded the contents off of Mr. Brackman's phone. And let me say this, the screenshots given to the police could have been doctored in any manner. So if finding the murderer was really their motive, they would have subpoenaed Alex's phone and downloaded the information needed.
Professor Van Owen, in your expert opinion, did Avery Becker kill Mackenzie Brackman?
No, the evidence doesn't line up for it to have been Avery to be the one to kill Mackenzie Brackman. Instead, in my opinion, more evidence leads to Blair Rollins to have committed the murder.
And who is Blair Rollins?
Blair Rollins is the child of Jonathan Rollins, who was actually a former client of Mackenzie Brackman.
And why do you believe that it was Blair Rollins?
Well, one, Blair has a stronger motive to kill Brackman than Avery, since Mr. Brackman was the reason that their father was put into prison and given a life sentence. And two, on the day of the murder, Blair was not at school.
And what factors did you rely upon coming to these decisions?
Well, it's as easy as 1, 2, 3. To start, Avery is a victim of circumstance. There are far too many discrepancies within this case to narrow it to just one suspect. There is absolutely no confirmation tying Avery Becker to the death of Mackenzie Brackman. There are too many holes within the prosecution's case. First, we cannot pin Avery's phone to just one cell tower. Second, there were too many overlooked suspects. And third, and finally, there's no DNA evidence, there's no face to the perpetrator, and there's only a generalized height and build for the suspect. There's no way to say that there was only one suspect, and specifically that it could and is Avery Becker.
Thank you, Your Honor. No further questions at this time.
Give just a second for the scoring panelists. Whenever you're ready, Mr. Winton, cross-examination.
Allow me one moment to adjust my camera. Good evening, Ms. Van Owen. You talked a lot about your CDR interpretations in this direct, correct?
Correct.
However, you have zero training in CDR.
I've not provided any, no.
You didn't provide a curriculum vitae?
No.
Now, moving on, you used to work for the Aurora Police Department, is that correct?
That is correct.
Until you left because you injured a young woman of color.
Yes, that's what happened.
Objection, Your Honor. Improper character evidence.
Response?
Your Honor, as pursuant to Rule 404, 404A, actually, we're not using this to show acted in accordance. We're not saying that she assaulted anybody in this case. Therefore, we're not using this to show acted in accordance, meaning that it is not improper character evidence.
Can I have an offer of proof of what you would be using it for?
This is proper cross-examination to go to the quality and credibility of this witness and to also explain to the jury why, in fact, she left Aurora Police Department.
Response?
Your Honor, I believe that this is something, if they would have brought it up, would have been brought up on a voir dire. I don't believe that the credibility of my witness has anything to do with this right now. And if they had any questions to the credibility of her as an expert, that it should have been brought up on voir dire instead of right now. And that this is improper character evidence, as they are characterizing her in a way that that is not true to herself.
Is it a misdemeanor assault conviction?
The facts on the case for this, it was tried, but they did not, in the case, she was not allowed to re-bring it back up in her affidavit because of the details of the case.
Okay, do you agree with that interpretation, sir?
Yes, Your Honor.
Okay, so I'm going to sustain the objection for character evidence. We're going to strike the assault conviction and the question from the record. You can continue whenever you're ready, sir.
Your Honor, just for clarification, am I allowed to bring up that there was an incident, or do I just need to move on?
I'd advise you to tread lightly if you are going to go in the area. I think the existence of an assault charge or an assault conviction, as unclear as it is in this case, is not something that goes to credibility, but is in fact a character trait or a past bad act, either way.
Yes, Your Honor. Ms. Kuzak, you left because there was an incident between you and a young woman of color.
Yes, I did.
Now, since you left the Aurora PD, you've become a private investigator and a professor.
Yes.
And your job requires that you testify in court.
Yes, that's correct.
However, you have only ever testified on the side of the defense.
Yes, I have.
And you are even being paid for your testimony today. Is that correct?
This is a job.
So that's a yes to my question. You are being paid by the defense for your testimony.
Yes, I am.
Now, let's talk about the many, many conclusions that you came to in this case. I'd like to start with your idea of what happened at the beginning of the break-in. You claim that there's very little evidence of a struggle?
Yes.
You claim this because we don't have a before and after of the crime scene, therefore it's impossible to say there was a struggle.
I'm not saying that it's impossible. I'm saying you just cannot come to an exact conclusion.
Is that a yes or a no to my question?
No.
And can we agree that you don't believe there was evidence of a struggle?
I don't find it accurate that there is proof to prove that there was a struggle.
You are aware of Exhibit 9?
Yes, I'm aware of it.
And you are aware that it is an exhibit of a broken plate on the floor?
Yes.
Now, it's reasonable to assume that if a person broke a plate, they would clean it up relatively soon?
Yes.
Now, you never went to the scene of the crime?
No, I did not.
And Ms. Kuzak and Detective Markowitz did?
Yes, they did.
But a lot of what you say contradicts their conclusions. Is that correct?
Yes, that's correct.
Now, let's move on to what you think happened when Mr. Brackman was stabbed. You believe that he would have had to been sitting down?
Yes, for the stab wound to be downward, that makes the most sense.
That's a yes to my question. You believe he was sitting down?
Yes, I do.
Meaning he would have had to have been surprised.
Could you please re-ask the question?
Absolutely. Mr. Brackman would have needed to have been surprised in order to still be sitting when he was stabbed.
Not necessarily surprised, but unaware.
Now, the back door leads directly into the kitchen?
Yes.
And the intruder entered through the back door?
Yes.
And Mr. Brackman was sitting in the kitchen?
I guess you could say that, yes.
Now, I'd like to talk about the Ring app. You disagree that the Ring app would have alerted Mr. Brackman, as he simply could have turned notifications off?
Yes, because the prosecution detective.
So that's a yes to my question.
Records did not.
So that's a
give
yes to my
records
question.
Objection, Your
Hold on,
Honor.
hold on. Okay, we're gonna make sure that we let the witness finish. Everybody just take a breath real quick. Please re-ask your last question. We'll let the witness answer the question. I understand witness control is a technique, but let's keep it professional, please, okay?
Yes, Your Honor. Ms. Kuzak, yes or no? You believe that Mr. Brackman could have turned off notifications on the Ring app.
Yes, I do.
And however, you never searched his phone?
No, I did not, but the prosecution witness Detective Markowitz did and didn't obtain these records.
Objection, Your Honor, non-responsive. I have asked a properly framed yes or no question. The witness has gone far outside the scope of this question. As this is a timed competition, if she has more context that she would like to lay to this answer, she can do so on her own time during redirect.
May I respond, Your Honor?
Yes, please.
I believe that his question is asking for more than a yes or no answer, as it may be framed as a yes or no answer. It calls for an explanation, as well as I believe my witness is not refrained to only a yes or no, and that if she feels like the need that she can, that she needs to explain further on this, that she can.
Yeah, so this isn't so much a rules of evidence question as it is a rules of fair play. I don't think the witness was trying to waste your time, sir. I think the witness was trying to provide an answer. I will instruct the witness to try and please keep your answers short and be aware that this is a timed competition. Let's play by the rules both ways. So again, technically, the objection is overruled such that it was an objection, but again, I'll allow you to re-ask the question. Witness, you may re-answer, and that's your choice, sir. You don't have to re-ask the question if you don't want to. But again, ma'am, I'll instruct you to please keep your answers within the spirit of the competition.
Ms. Kuzak, or Ms. Van Owen, excuse me. Yes or no, you did not search Mr. Brackman's phone?
No, I did not.
So you do not know whether or not he had notifications on, yes or no?
No, I do not.
Now, finally, you don't believe Avery Becker committed this crime?
No, I don't.
So let's talk about who you do believe committed this crime. You believe that it was Blair Rollins?
Yes, I do.
However, the only evidence that you have that Blair Rollins committed this crime was that he was not at school today. Is that correct?
And a little bit of the idea that Mackenzie Brackman is the reason that their father was put into prison.
So the only actual evidence that you have is that Blair Rollins was not at school that day, yes or no?
Yes.
Now, Ms. Becker and Ms. Perkins were not at school that day either?
No, they were not.
Thank you, Your Honor. No further questions.
Okay, redirect.
Yes, Your Honor.
I'm sorry, give me just a moment. I want to let the scoring panelists have just a second, so please don't start the time. Okay, now you may proceed, please, and obviously start the timer. Thank you.
Ms. Van On, why have you only testified on the defense's side?
Well, after leaving the Aurora Police Department, I had realized that there were some issues that could be discussed. So I took it upon myself to work on behalf of the defense, because after that experience, you know what to look for and justice should be served.
And is it normal for you, Ms. Van Owen, to get paid for your job?
Yes, the majority of people working do get paid for jobs.
And what would you call this pay?
Could you elaborate on that question?
Like what, for what you're being paid on this case, like is that what you would consider a normal salary?
Yes, I would.
And lastly, why do you think that that Mr. Brackman may have had his Ring notifications off?
Well, as someone who also has a Ring doorbell, I understand how annoying the notifications can be.
Thank you, Your Honor. No further questions.
I'm not going to allow a recross on that. May this witness be excused?
Yes, Your Honor.
Okay. Defense, do you want to call your next witness, or do you have another witness to call, I guess?
Yes, Your Honor. The defense would like to call Taylor Perkins to the stand.
Okay. I guess Miss or Mr. Perkins, you are constructively sworn in. Again, I'll interrupt if any technical issues happen that I can't hear. I think that's enough time for the scores. So whenever you're ready, sir.
Yes, Your Honor. Please state your name and spell the last for the record.
Taylor Perkins, Perkins.
And Mr. Perkins, can you tell me how you know Avery Becker?
Avery is my best friend, and I can't believe it's come to me having to testify for her when it's something I know she would never do. Avery would never have killed Mr. Brackman. She couldn't have, and she wouldn't have.
And why can't you believe she's being held on trial today?
I mean, we were together the entire day. My best friend Avery, she's a teenage girl. Mr. Brackman is a grown man. Put those together, that it just doesn't make sense. I just can't believe he's really gone.
I know how hard this must be for you, but I want to walk you through the events that happened on March 5th, if that's okay.
Mm-hmm.
Where were you?
Well, Avery and I were at my house playing video games on our phones, and then we decided to go to the Fry Shack where all the mock trial students like to go.
Tell me about that.
Well, everybody was there, the entire mock trial team, and even Alex Cifuentes.
And who is Alex Cifuentes?
Alex is a student on our mock trial team. She never really got along with Avery that well. It's like she was jealous of Avery's skill set.
Tell me about what happened at the Fry Shack.
Well, Avery must have gotten pretty upset because she had stormed off to the bathroom and left her phone on the table. Avery never forgets her phone. It's like it's joined to her hip. But once Avery came back, we left the Fry Shack.
And who was there when you guys were leaving?
Unsurprisingly, Alex was still there at the table, sitting down.
I want to move to the events of March 6th. What were you doing that morning?
Well, Avery came by and picked me up for school, which was normally occurred because we rode to school together all the time. But that's when we realized her phone was missing.
And what did you guys decide to do when you guys realized her phone was gone?
Well, we looked everywhere. We went to the Fry Shack, we went to the mall, and any other place that it could have possibly been that we were at the night before.
And did you guys ever find Avery's phone?
No, we never did. It's still missing.
Taylor, I want to ask you to think very hard and try and remember the last place you saw Avery's phone.
Well, I remember seeing it at the Fry Shack where we had left Alex sitting down at the table.
Moving back to your previous testimony, you talked about being with Avery all day on March 6th, but what does that mean?
We were together the whole day, like from when school started to when mock trial practice would have been starting. Like there's no way we could have been anywhere near Mr. Brackman. We were together.
Finally, Mr. Perkins, as someone who's known Avery for a long time and been close with her, what are your thoughts on all of this?
Well, it honestly just sickens me that my best friend is being accused of murdering our coach. She's facing prison for this. It really hurts me that Mr. Brackman's gone and that Avery is being accused for it.
No further questions at this time, Your Honor.
Cross-examination? I'm sorry, give just 1 second for the scoring panelists. Okay, cross-examination,
Yes, Your Honor.
proceed.
Good afternoon, Mr. Perkins. You testified that Miss Becker and your former coach had a difficult relationship, correct?
Yes.
And this was because Mr. Brackman believed Miss Becker did not put enough time into mock trial, yes or no?
Yes, Mr. Brackman was always criticizing Avery's work.
Therefore, her lack of time spent on mock trial affected the team, correct?
I would say so. I mean, most of it was Mr. Brackman getting upset with Avery, but I would say so, yes.
You also previously stated that Miss Becker was kicked off the team after an incident with your coach's car, yes or no?
That's correct. That did happen.
And this incident was when Miss Becker wrote Worst Attorney Award on your coach's beloved Porsche, correct?
Yes, she did.
You previously mentioned that Miss Becker could be rash. Do you believe her decision to write on your coach's beloved car with a permanent marker was a rash decision?
I would say so, yeah. That's pretty rash.
And you believe Miss Becker being kicked off the team was a punishment for her vandalization of your coach's car, yes or no?
Yeah, I would say so.
So to clarify for the jury, Miss Becker was kicked off your team by Mr. Brackman as a punishment for her vandalization and rash decision. Yes or no?
Yes, that did happen.
Moving on, you mentioned that Miss Cifuentes and Miss Becker were not the closest of friends, correct?
Yes, that's correct.
But you did know that Miss Becker planned on contacting Miss Cifuentes?
Yes, she contacted everybody on the team to try and get a chance to get back on.
And Miss Becker was contacting her former teammate because of her disagreement with Mr. Brackman?
Could you re-ask the question? I couldn't hear you that well.
Would you
Your
say
Honor?
Miss Becker?
Go ahead.
I was disconnected from the call. I don't know if it showed me leaving or not, but I have not heard around the last 3 or so questions. I'm assuming I was kicked out and I was out for about 30 seconds.
I apologize that I missed that. What I'm going to propose, Madam Prosecutor, is that we stop the clock. You re-ask your last 3 questions so that Mr. Maher can actually hear them. Do you have an objection to that? And courtroom monitor, is there a problem with proceeding in that way?
I have no objection to that.
That works.
Okay, so we'll stop the clock, please. Mr. Maher, what was the last question that you heard? Are you there?
I can now hear you, and I'll let you know if I get disconnected once again. Thank you.
Okay, so what we're going to do is stop the clock. She's going to re-ask the last 3 questions. The witness is going to provide as close as you can the same answers, please. And sir, I just asked what was the last question that you heard, if you recall. Mr. Maher.
Sorry, I was muted. I believe it was talking about being rash, Avery being rash.
Madam Prosecutor, does that get you close enough to be able to resume your line of questioning?
There was 2 questions with the word rash, so if I do not start on the right one, please feel free to interrupt me and I can go back to the other one.
I believe it was the second one,
Okay.
if I remember correctly.
Okay, thank you very much. So we'll ask the next 3 questions and then we'll resume the time and pick up the cross where we were.
Yes, Your Honor. Mr. Perkins, to clarify for the jury, Miss Becker was kicked off your team by Mr. Brackman as a punishment for her vandalization and rash decision, yes or no?
Yes, that did happen.
And you also mentioned that Miss Cifuentes and Miss Becker were not the closest of friends, correct?
No, they really didn't get along that well.
However, you did know that Miss Becker planned on contacting Miss Cifuentes, yes or no?
Yes, Avery had contacted really the whole team to try and get back on, even Alex.
Okay, so let's resume the time. Madam Prosecutor, please continue.
However, Miss Becker never mentioned her conversation with Miss Cifuentes to you, correct?
That's correct.
Therefore, you have no reason to say that these texts are inaccurate. It seems that Mr. Pullen may have been kicked off again.
Yeah,
I do
Mr. Mark.
not.
I just got back.
Okay.
I'm so sorry for my internet connection.
Let's
I
pause there for a
started
second.
hearing.
Okay. Mr. Maher, can you hear me?
Anybody text him and tell him to just call in on his phone?
Yeah, would one of the teammates please text Mr. Maher, let him know to call in on his phone, have his camera on, but he can have his microphone on his computer muted so that we don't get a feedback issue.
Are you guys able to hear me now?
Yeah, we are. Let's try and proceed then. Please resume the timer. Ma'am, please re-ask your last question.
Therefore, you have no reason to say that these texts are inaccurate when you do not know the details of their conversation. Yes or no?
That's correct, yes.
Moving on, you were interviewed by Kyle Kuzak about the whereabouts of Miss Becker on the day the murder took place, correct?
That's correct.
And this was because you and Miss Becker skipped school on March 6, 2020?
Yes, we skipped school and looked for her phone the entire day.
During your interview, you also testified to the distance between Miss Becker and the victim's house, correct?
That's correct.
And this was because you claimed to have been with Miss Becker the entire day the murder took place?
Yes, it was from when school started to when mock trial practice would have started.
However, as you just said, Miss Becker, she only picked you up once school started, and because you both had first period off, that's why you rode together, correct?
That's correct, yes.
Therefore, you cannot actually account for Miss Becker's whereabouts in the morning before she picked you up from school. Yes or no?
Could you re-ask that? You were cutting out.
Of course. You cannot actually account for Miss Becker's whereabouts in the morning before she picked you up from school. Yes or no?
That's correct, yes. That I cannot.
So you were not actually with Miss Becker all day?
Like I said, it was from when school started, when mock trial practice would have started, and from when she had picked me up in the morning.
Moving on, would it be accurate to say?
Please pause the timer, ma'am.
Your knowledge, Miss Becker felt angry and disappointed about being kicked.
Please pause the timer. We're having trouble again. Man, oh man, we are getting real lucky tonight. Ma'am, are you able to hear me? Miss Burton?
Yes, I am. Can you hear?
Yeah, you're kind of coming in and out and modulating as a robot.
Oh,
It sounds better now. Let's start the timer and try to get through this.
You can try just changing your microphone settings with the caret on the mute next to the mute thing. Sometimes if you go to one and then jump to another one, it'll fix it. But we can just try it again real quick. But try that a bit.
okay.
Proceed.
To the best of your knowledge, would it be accurate to say Miss Becker felt angry and disappointed about being kicked off the team?
Yes, I would say so, yeah.
And you said previously that you felt your coach's decision was unfair, correct?
Yes, I do say that.
So to the best of your knowledge, it would be accurate to say that Ms. Becker also felt that your coach's decision was unfair?
Yes.
Therefore, Ms. Becker, to the best of your knowledge, had many mixed emotions about your coach after her decision to remove her from the team, correct?
Objection, Your Honor. Speculation.
Response?
Yes, Your Honor. Your Honor, this is not speculation pursuant to Rule 701. This is proper lay witness testimony rationally based on the witness's perceptions and observations from knowing Ms. Becker and Mr. Brackman.
Mr. Maher?
Your Honor, I believe that the previous questions he was asking, yes, they do fall under Rule 701A, rational based perception. But I believe that this question asking about mixed emotions cannot be simply a yes or no and or be answered by anyone other than the defendant herself.
Yeah, I'm going to give the same response that I gave earlier. If the witness knows, the witness knows. And the way that the prosecutor phrased the question was to the best of your knowledge. So I think it is a fair question. I'm going to overrule the objection. Thank you for your objection, though, sir.
Mr. Perkins, would you like me to re-ask the question?
Yes, please.
Ms. Becker, to the best of your knowledge, had many mixed emotions about your coach after his decision to remove her from the team, correct?
I would say so, yes.
And Ms. Becker's previous rash decision was also when she had many mixed emotions about your coach's disapproval of her work ethic, correct?
That's correct, yes.
Mr. Perkins, do you believe Ms. Becker's mixed emotions about your coach's decision to remove her from the team, to your best of your knowledge, could have caused her to make a rash decision like her former car vandalization?
I would say that the car vandalization was rash, but I can't see Avery going farther than that.
However, Ms. Becker was angry at Mr. Brackman, yes or no?
Yes, Avery was.
Thank you. No further questions.
Okay, redirect.
Yes, Your Honor, very brief.
Thank
Mr.
you.
Perkins, you talked about mixed emotions, Mr. Perkins, just because somebody does a prank, does that mean that they're going to commit murder?
No, Avery would never do such a thing. My best friend, she would never kill Mr. Brackman or attempt to burglarize his home.
No,
Did we?
sorry, my internet is acting up. And to the best of your knowledge, where was Avery on March 6th?
Well, we were together. When school started, when she picked me up, and all the way until when mock trial practice was starting. So she was with me on March 6th.
No further questions at this time, Your Honor. And barring no recross, I ask that my witness is able to step down from the stand.
I'll offer a recross, Madam Prosecutor.
No recross, Your Honor.
Okay, the witness is excused. Thank you for being here. Give just a moment for the scoring panelists. Okay, defense, do you have any additional witnesses you'd like to call?
Yes, Your Honor. The defense would like to call Avery Becker to the stand.
Okay. Sorry, again, I'm looking at a very small screen. Mr. or Miss Becker, you are sworn in.
May I proceed, Your Honor?
Whenever you're ready.
Good evening. Please state and spell your last name for the record.
Avery Becker, Becker.
And Miss Becker, you went to Colorado High School, the Colorado High School last year. Is that right?
Yes, I attended as a senior.
What activities did you participate at the high school?
I was part of CHS's mock trial team for 4 years.
And Mr. Mackenzie Brockman was your coach, right?
Yes, Coach Brackman was my coach. I can't believe he's gone.
And I know this is very hard for you to talk about, but could you describe your relationship with Mackenzie Brockman?
We didn't have the best of relationship in terms. Coach Brackman didn't like my work ethic.
What happened because of these conflicts with your coach?
About a month before regional competition, Coach Brackman demoted me to B team.
What happened after you were demoted?
I tried talking to coach to get back on to A team, but that didn't work out. So Taylor had this idea to quit, and he thought A team couldn't win without me. He didn't really like my trial.
I'm sorry, what was that, sir?
Pursuant to Rule 701, I believe that statement was speculation.
A response to speculation?
Your Honor, pursuant to Rule 701A, this is the witness's rationally based perception. As they have been best friends, they would know and as you've heard from Taylor Perkins' prior testimony, I believe that Avery Becker would have knowledge of whether they quit the team for them or not.
Yeah, I'll give you a response if there's something more specific, but if it's just about knowledge of being on the team, I tend to disagree. So I'll give you the last word.
Yes, Your Honor. I am not objecting to what Ms. Becker believes were the perceptions and observations of Ms. Taylor Perkins, but rather Ms. Becker has just testified to what Mackenzie Brackman was thinking, and as she is incapable of such an ability, this is speculation.
Okay, I missed that exact phrasing, so I would agree. I guess it's not the last word. One last response. Did your witness say something about what Mr. Brackman was thinking?
Your Honor, my witness's statement was that they quit the team for them. It's not saying that they were inside their head thinking for them.
Okay, so I guess I don't have the transcript. I don't know exactly what was said. Witness, I'm going to instruct you to stay within the bounds of what you saw, what you observed, and not what anyone else is thinking. You can re-ask the question, sir. If it's a problem again, sir, you can re-object. But for now, I guess I'm going to, again, technically overrule the objection.
Yes, Your Honor.
Ms. Becker, were you finished with your response?
I was just going to say that after that, I was put on an A team again.
Let's talk. Did you have any other conflicts with your coach afterwards?
Yes, after regional competition and just winning, Coach Brackman got on me and said that my work wasn't up to his liking. So in that moment, I grabbed a marker and wrote "Worcester turning water across the hood of his car." It was the dumbest decision of my life.
What were your feelings after that event?
After I calmed down and talked with my mom, I realized I made a terrible mistake.
And you obviously seemed that you were upset at the time. What did you say to your mother?
I told her that if it was the last thing I do, I would try to get at Coach Brackman if it was the last thing I did.
And did you mean what you said?
No, I mean, in that moment, I thought I was right and I meant it, but after calming down, I realized I was wrong for my whole mistake, and to write on this call, I didn't.
After you realized that you had made a mistake, what did you do?
The next day I went to Coach Brackman's office to apologize to him, but he didn't want to see me, so I offered to work the whole summer to pay off for the damages I did, but I never got the chance to apologize to Coach Brackman in person.
And I know it's really hard to talk about your coach, but I'd like to direct your attention to March 6th of 2020, the day that your coach passed away. Where were you on that day?
I was with Taylor, my best friend, all day. We went to the mall and the Fire Shack to look for my phone that I lost the day before.
When did you last see your phone?
I last saw it March 5th, the day before Mr. Brackman's death.
And where did you last see your phone?
I last saw it at the Fire Shack. The whole mock trial team was there, including Alex.
How did you try to find your cell phone?
Taylor tried calling and texting my phone, but we didn't ever find it.
Now, I'd like to direct your attention to the investigation that was led into you for this investigation. Were you were present here when Miss Kyle Kuzak testified about alternate suspects in this case, right?
Yes, I was, and I'm surprised to hear that there were 1, 2, but 3 suspects. I'm surprised I was the only one that was investigated, not the other 2 suspects.
Are you acquainted with any of the other suspects?
Yes, I go to school with both Blair Rowlands and Alex Fuentes.
Who is Blair Rowlands?
Blair was a fellow classmate of mine. I'm surprised they weren't investigated.
Why do you say that?
Blair is similar in size to me, and most people can easily confuse the 2 of us.
You also mentioned that you knew Alex Fuentes. Who is Alex Fuentes?
Alex is a fellow mock trial teammate of mine. I'm surprised she called me her friend. We just teammates and nothing more, and that she was jealous of me.
And you heard
Your Honor, speculation and improper character evidence.
Response?
Your Honor, as you heard from direct examination today, and since Ms. Becker was present for that, Alex Fuentes said that they were jealous of Avery Becker on direct examination made by the prosecution.
Response?
Your Honor, Ms. Becker made no clarification that she was speaking to the testimony here in court today, and is rather basing her belief off of things that she has noticed in the past.
So again, I agree with you that it would be speculation if it were not testified to here earlier today. So I am going to overrule the objection and clarify for the record that the witness was speaking in regards to testimony that we did hear during the prosecution's case in chief.
Yes, Your Honor.
Ms. Becker, did you finish your response?
I did.
Now, you were present when Ms. Fuentes talked about a cell phone conversation with you, right?
Yes, I was there for that.
And I'd like you to reference exhibit number 14 for me, please. Do you recognize what it is?
I'm not really sure. I've never seen these before.
Did you send any of these text messages?
No, I've never texted Alex.
Now, Ms. Becker, I just have 2 more questions for you. Did you break into Mackenzie Brockman's residence?
No, I don't even know where Coach Brackman lives.
And Ms. Becker, would you do anything to hurt Mackenzie Brockman?
I would never do such a thing to Coach Brackman or anyone.
And Ms. Becker, did you kill Mackenzie Brockman?
No, I could never hurt Coach Brackman, nor do something like that.
Thank you, Your Honor. I have no further questions at this time.
We'll give just a brief moment for the scoring panelists. Whenever you're ready, sir.
Yes, Your Honor. Ms. Becker, in your opinion, you were the best competitor on your mock trial team, correct?
Yes, I mean, I did win the Best Attorney Award in closing at the regional competition last year.
And you felt that mock trial came naturally to you, and that you had to place little effort into your work. Isn't that right?
That's like you said it, but it just came naturally to me. So I didn't put in as much work as I guess some of my teammates.
However, the victim, your head coach, did not share this opinion, did he?
No, he didn't like my work ethic.
In fact, your relationship got to the point that you felt it right to vandalize a vehicle that he obviously cared for, correct?
It was right after a regional competition. He started critiquing me. So in that moment, I was just irritated, but I regret that decision.
And Miss Becker, you vandalized his vehicle with a permanent marker, correct?
Unfortunately, I did.
And the reason that you vandalized his vehicle was because the two of you had just entered one of your strongest and most heated conversations yet. Isn't that right?
I mean, I guess you can say that, but I was just irritated then.
But despite the fact that the argument got quite heated, Mr. Brackman walked out into the parking lot, apologized to you, and invited you back into practice, didn't he?
Objection, Your Honor, compound question.
Response?
Your Honor, this is all adding up to a single question that I will be asking the witness.
So I take it to mean what you're saying is you're circling back to questions that you had asked previously? Is that right?
Your Honor, this is a clarification of what Mr. Brackman was continuing to do after their conversation.
Okay. I guess just if you can please rephrase the question to make sure you're asking one fact per question. I think that probably was a compound question, so I am gonna again technically sustain it, but you can re-ask your question, just one fact per question, please.
Your Honor,
Yes,
I move to strike the question from the record.
Yes, it shall be. Jury, please disregard the prior question.
Miss Becker, after the argument, Mr. Brackman walked out into the parking lot, correct?
Yes, he did.
Mr. Brackman walked out into the parking lot and apologized to you, yes or no?
He tried apologizing to me until he saw what I did to his car.
But Miss Becker, the only reason why he stopped his apology was upon realizing what you had done to something precious to him, correct?
Yes, and I was completely wrong for riding on his car like that.
So we can agree that the relationship between you and Mackenzie Brackman was rocky, to say the least.
Yes, we didn't have the best of relationships.
Now, later, when the victim had kicked you off of the CHS mock trial team, you reached out to Miss Alexi Fuentes for help getting back on that same team, correct?
That is outside the scope of my affidavit, but if you want me to answer, I can.
Please.
No, I didn't. I didn't text Alex ever.
But, Miss Becker, you were here for the deposition of Detective Jordan Markowitz, correct?
Yes, I was present for that.
And you heard her state that when you tried to get back on the CHS mock trial team and failed, you texted Alexi Fuentes for help.
Not Alex in particular, no.
But Detective Jordan Markowitz did in fact say that, correct?
The Detective Markowitz said that, but I didn't do that.
Your Honor, let the record reflect that my trial technician is displaying what has been previously marked as Exhibit 14 and has been admitted into evidence.
Okay. Do a brief pause of the timer, please. Okay, to start the timer, you may continue.
Miss Becker, in this conversation, that Missy Fuentes has testified under oath that the two of you had, the Avery Becker of this conversation says, "I'm pretty desperate to get back on."
Objection, Your Honor. Attorney testimony.
Response?
Your Honor, I'm speaking to an exhibit that is here present in front of opposing counsel and Avery Becker.
Yeah, I'm gonna again technically overrule this objection. I think you're allowed to use phrasing from the exhibit in order to ask the question. Obviously, please don't linger and be cumulative.
Yes, Your Honor. Now, Miss Becker, the Avery Becker of this conversation here says, I'm pretty desperate to get back on. Is there any way you'd be willing to talk to Coach Brackman about having me back, correct?
Well, that might be my name, but I've never sent those text messages before.
And Missy Fuentes clarified that when the victim was not willing to budge on the matter, you made a plan to break into and trash the victim's house, correct?
I've stated numerous of times, I have never sent those text messages. It might be my name, but it's not my contact.
Ms. Becker, Alexi Fuentes clarified that fact, correct?
I never texted Alex, so I don't know how she has these.
Ms. Becker, moving to the date of March 6, 2020, the day of Brackman's murder, you say that you were with your best friend Taylor Perkins, correct?
Yes, I was with him all day. We were looking for my missing phone.
This being the phone that Detective Markowitz placed at the scene of the crime within 2 hours from when the body was reported, correct?
Objection, Your Honor, argumentative.
Response? And please take down the exhibit unless you're not finished with it, I guess, but it
No,
seems
it's finished, Your Honor, yes.
Okay. Response to argumentative.
Your Honor, would opposing counsel clarify their objection?
Okay, sir, you want to add a little argument to your argumentative objection?
Yes, Your Honor. Opposing counsel is arguing that this phone is placing my client at the scene of the crime, and that's arguing the statement. It's not asking whether Jordan Markowitz said this or Jordan Markowitz said that. He's clearly opposing counsel is clearly arguing a point that this phone was at the crime scene and is pinpointing and is making that argument to the jury without asking a question.
Sir, can you please repeat your question and then give me your response to counsel's specific argument?
Yes, Your Honor. The question was, Ms. Becker, Detective Markowitz has clarified that this was the phone that was found at the crime scene within 2 hours from when the body was reported. And as such, Your Honor, I believe that this is not argumentative. Well, it falls within proper cross-examination.
Yeah, I tend to agree. I think the question probably has some bite to it, but I don't think it's inappropriate. So I will overrule the objection. Thank you for the objection. You can continue, and witness, please consider his re-asking that he just did for me a re-ask to you.
I guess, but I didn't have my phone that day. As I said, I lost it the day before, March 5th.
And specifically, to explain the fact that Detective Markowitz placed your phone near the scene of the crime, you state that Alexi Fuentes and Blair Rollins might have stolen your phone, correct?
That's in my affidavit.
But half the basis for this belief is because Blair Rollins had the same build as you, yes or no?
Yes, people easily might have mistaken Blair and I.
The other half of this belief, Ms. Becker, was because Miss Alexi Fuentes was jealous of you, correct?
Yes, as she stated today in court.
Thank you, Your Honor. No further questions.
Okay, redirect.
Yes, Your Honor. Referring to Exhibit 14, Ms. Becker, did you send any of those text messages?
No, I've never sent them, nor have I seen them before today.
And Ms. Becker, where were you, again, to clarify for the jury, where were you on March 6th?
I was with Taylor all day and we went to the Fry Shack in the mall to look for my missing phone.
Thank you, Your Honor. I have no further questions, and barring any recross, I ask that my witness be allowed to step down.
I will offer a brief recross if you'd like one, sir.
No recross, Your Honor.
Okay, the witness can be excused. Does the defense have any additional witnesses to call, or are we proceeding to closing?
No, Your Honor. The defense raised its case in chief.
Okay, and are there any motions to be raised before we go to closing argument?
No, Your Honor. The defense is ready for closing arguments.
All right, from the prosecution, please. I'm sorry, let's give the scoring panelists just a moment.
Yes, Your Honor.
All right, please proceed.
Your Honor, before I begin, I ask to reserve any remainder of time for a rebuttal.
It shall be reserved, and would I possibly be able to know what the time frame is on a closing? I forget.
5 minutes, Your Honor.
5 minutes, thank you.
May it please the court.
Proceed.
A knife in the back. Members of the jury, Mackenzie Brackman was found just outside his door in a pool of blood with a knife wound in the back. Mackenzie Brackman was a dedicated member of society. He made movements to bring justice to those who needed it and put forth extra time and effort to teach young adults the very practice that can save many from unjust punishments. But because he was willing to improve the obvious talent in a young pupil, he was made the victim of a cruel and devastating murder with a knife in the back. A history of conflict has been made clear between the defendant and the victim here today. They had argued in almost every one of their practices, and when the victim had deemed it appropriate that the defendant be removed from the CHS mock trial team, the defendant acted out and wrote Worst Attorney Award across the hood of the victim's precious 1986 Porsche vehicle. The defendant was let go from the CHS mock trial team for good, but Ms. Becker was not willing to accept this yet. She reached out to Ms. Alexi Fuentes, who has testified under oath today, and asked for help to get back on that same team. The victim did not allow Becker back on the team. And as a result, the defendant wrote to Missy Fuentes saying, if he's still upset about what I did to his car, then he's going to be really upset when he sees what I do to his house. That single phrase, along with multiple strings of evidence, placed Avery Becker at the scene of the crime on March 6th, 2020. The prosecution holds the burden of proof in today's case. We must prove to you beyond a reasonable doubt that Avery Becker committed both burglary in the second degree of a dwelling and murder in the first degree. Now, a reasonable doubt is a doubt based upon reason and common sense, which arises from a fair and accurate view of the evidence and each element of the crime. If you find that the evidence and each element of the crime has been proven, then you must find the defendant guilty of such crimes. Members of the jury, today my co-counsel introduced ourselves by saying that we would prove Ms. Becker committed both murder in the first degree and second degree burglary of a dwelling. With the testimony given in these past few hours, we have met that burden. With the testimony given in these past few hours, we have proven that Mackenzie Brackman was left alone in a pool of blood with a knife in the back. This betrayal was brought on by a single person. That one person is Avery Becker. Vote in the name of justice. Find the defendant guilty. Thank you.
Okay, we'll give just half a moment for scoring panelists and we'll go into defense closing. And timekeepers, how much time does the prosecutor have remaining for his rebuttal? 41 seconds, it looks like. Thank you.
It's actually 1 minute and 41 seconds. I made a mistake.
1 minute 41. Gotcha. Thank you. All right, defense closing, please.
Yes, Your Honor. Your Honor, opposing counsel, and members of the jury, this case is as easy as 1, 2, 3. And we'll start with the first point of tragedy, that Avery Becker is not getting the justice she deserved. And before I begin, I'd like to remind all the jurors of jury instruction number 2, that our client, Avery Becker, is presumed innocent unless and only if the prosecution can prove beyond a reasonable doubt all aspects of the charges, specifically jury instructions number 7 and 8. And that's where I'd like to start off, ladies and gentlemen of the jury. They have failed to prove 2 key aspects of the charges. Number 1, you have not seen any of their witnesses today identify or correctly identify Avery Becker for you today. How do we know that this Avery Becker who committed these crimes, if they committed these crimes, is the same person sitting in the defendant's seat? How are we to know that our client is the same person? Then, second, they have failed to prove any location of where this occurred. They have not proven to you beyond a reasonable doubt that this crime was committed in Colorado or even where Mackenzie Brockman was. We do not know the exact and precise location of the crime, and based on those aspects alone, you must find Avery Becker not guilty of first-degree murder and not guilty of second-degree burglary. However, I'm going to tell you more holes in this case. I'm not obligated to do so, but I'm going to show you all the holes in this case, and that brings me to our second point of a tainted investigation. You heard from Jordan Markowitz testify today about the inaccuracies and inconsistencies between the photographic evidence, mainly the murder weapon, as well as the deceased's body. That this crime scene was tainted, that the body had been moved, and that the knife is not in the same original condition, or possibly not even the same knife at all. Ladies and gentlemen of the jury, that's reasonable doubt. That they are not the same. It's not imaginary doubt, it's reasonable. Anyone reasonably can see easily that the crime scene has been tainted. You also heard from Alex Cifuentes, and focusing on Exhibit 14, the reliability of these text messages. However, half of this exhibit was not even admissible to you, the jury. You are missing that crucial context of a conversation. And then again, this cannot be even proof that Avery Becker had any intent or knowledge of going to Mackenzie Brockman's residence. Lastly, ladies and gentlemen of the jury, for tainted investigation, we look at Kyle Cusack's testimony that they relied heavily that the person in the Ring video camera matched the same general height and build as Avery Becker. Avery Becker has a lot of similar height, including Blair Rowlands. And that's where we go to our third point, ladies and gentlemen of the jury. Avery Becker was targeted because of a rushed and rash investigation, similarly to stabbing her in the back because she's not getting the justice she deserves. You heard from Avery Becker testify today that she would never do anything to harm her coach, and that she never even knew where Brockman lived. You also heard from Taylor Perkins as well as Avery Becker that they were together the whole day. They were off looking for their missing cell phone that they did not have because they lost it on March 5th. And that brings me to exhibit number 15, the call detail records, and another tainted investigation. You saw that Jordan Markowitz, while didn't investigating Blair Rowland, thought it was apparent enough to include him on their map. That they failed to not only investigate 1, 2, but 3 suspects, targeting exclusively Avery with no evidence. Ladies and gentlemen of the jury, you also heard from Professor Blake Van Owen, who testified about the lack of evidence. And because of that lack of evidence, Avery Becker was targeted because they had nowhere to go. They only had one inconsistent lead. Now, ladies and gentlemen of the jury, the prosecution bears the burden of proving to you beyond a reasonable doubt every single aspect of the charges. And as I've mentioned before, they have failed to prove multiple aspects of the charges, and therefore, based on that alone, you should find Avery Becker not guilty. Ladies and gentlemen of the jury, this case is as easy as 1, 2, 3. That there's a tragedy that occurred with Mackenzie Brockman, but a tragedy in this courtroom. That Avery Becker is a victim of circumstance, and that Avery Becker is innocent. You saw a tainted crime scene that placed Avery Becker with circumstance. And you saw the prosecution target Avery Becker because of circumstance. Find Avery Becker not guilty of the charges. Thank you.
We'll take just a half a moment for the scoring panelists, and then we'll go into prosecution rebuttal.
Yes, Your Honor.
Okay, Mr. Hernandez, I believe you have 1 minute and 41 seconds left. You may begin when you're ready.
Before I begin, Your Honor, can you see and hear me okay?
Yes, sir.
Very well. May it please the court.
Proceed.
Easy as 1, 2, 3. Members of the jury, the defense has asked you to focus on the tragedy of having lost Mackenzie Brockman, a dedicated member of society, and still not having found the accountable party guilty. The prosecution holds no dispute against that fact. However, a tainted investigation? A tainted investigation met by two separate expert witnesses is unlikely. And furthermore, let us look at the defense's one expert witness. Ms. Blake Van Owen was in fact able to provide an alternative theory to today's case. But keep in mind the much more important fact that she is being paid by the defense to testify here today. So while the defense accuses the prosecution of having a tainted investigation, the prosecution has just revealed to you that there was a biased investigation. And finally, Detective Jordan Markowitz and Kyle Kuzak, both with more than 7 years of experience in their designated fields, both designated a single party accountable with a consideration of all of the evidence. The tragedy of not having the accountable party yet. The clear investigation and the definitive conclusion of having Miss Becker guilty. It is as 1, 2, 3. Thank you.
My apologies about the interruption. I was able to hear the remainder of your closing argument. I do sincerely apologize about that, sir. We're gonna have everybody mute and kill their cameras while we allow the scoring panelists to submit their scores. Scoring panelists, please turn on your camera once you've submitted your scores so that I know when we can start doing feedback. Okay, it looks like our scoring panelists have all submitted their scores. Thank you so much. If everybody wants to at least turn on their cameras, I think we can do some quick feedback. Just to give you a little bit, well, first of all, did any of you do high school mock trial last year?
I did.
So you're gonna meet a celebrity from the high school mock trial world. This is Pepper, and she was the dog from The Problem last year.
The Pembroke Walsh Corgi?
Yep, yeah. That's this dog right here. So anyway, she wanted to say hello to you while you were closing still. So I apologize again about that, Mr. Hernandez. But anyway, feedback from me, I put my email in the comments. I know you guys are in the middle of a tournament. It's the third round. You all are incredibly well prepared. You've all done an incredible job. You know, working hard. You've been working together because you each have developed, you know, a cohesive theme among your team. I was really, really impressed with all of you. Witnesses, attorneys, I thought you did a great job. The level of professionalism was very high. It was a smooth, well-run round from you guys. So I just want to start by, you know, acknowledging all of your success because you have all done a wonderful job in putting on this case. The only real specific thing I have is that I love the way both of you incorporated your themes throughout. Knife in the back, easy as 1, 2, 3. There were a lot of trilogies in this case that set up the 1, 2, 3 very nicely. I think you all have a lot of potential. If you decide to be a lawyer, if you decide to do something else, I think you're all going to be very, very successful. And from my end, mock trial was the single most important part of my legal education. I did it all throughout law school. I've coached, I've done high school, scoring panelists, whatever. For me, mock trial is the single most valuable piece of a lawyer's education. So if that's your route, keep up the great work. And then if any of the other scoring panelists want to provide any feedback, again, my email is in the chat. You're more than welcome to reach out to me, and I'm happy to talk, for as long as you want to listen to me.
I'll go briefly. Between yesterday and today was my first foray into mock trial. Never participated, but I've got a firm. We do civil litigation primarily, and I thought it was a well-tried case. The two things that stood out, Will Dahman, objections on your feet. I thought some of those were very effectively used. And then is it Brendan Maher? I think your cross of Cusack, I made a note. I like the way that you were thinking on your feet during the cross, and your next question was keyed off of the response that was just given. I like watching people think on their feet. That's what trial's about. And getting some great concessions out of the witness. There were some objections, I always think trying cases that in some cases, just because you can make an objection doesn't mean you should. And there were a few times where I thought that they were a little overused and made me start thinking, like, what's the testimony they're afraid of? Like, get it out, have at it, and deal with it with your next question versus trying to prevent the jury from hearing it. That was my only criticism on the objections, but I thought it was a well-tried case, and congratulations to all of you.
I'll give a few comments as well. Hi, my name is Elizabeth. I am an attorney at a firm that does criminal defense and family law, and I was formerly a public defender. I thought you guys did a great job as well. I was really impressed. The objections really stood out to me too. I think objections generally are really difficult. You do have to be thinking on your feet. You have to object right away. And it's one thing to be able to blurt out what you think the objection is, but then to actually be able to articulate it. That was really impressive. There were a lot of you that really were able to articulate very clearly that you understood not only what the name of the objection was, but why you were objecting. So that was great. One general comment I'll say is, and I think every even attorney does this in trial, is watch the kind of the extra words on your questions. So some of you would start off every question with "and." Another person would end every question with "correct" or "right." Or, start it with "well," as a witness, you want to say, "well, X," right? So it's just being really cognizant of those little ticks that you have and being able to just be confident in the question that you have to ask without needing to tack that on. And sometimes it is appropriate. Sometimes you'll have a question or a witness who says something like, "Are you asking me a question or is that a statement?" And then you might want to add that on, but try to make it more purposeful than out of just habit. Let's see. And then I think one other thing I'll bring up is the point of keeping your questions to one fact per question if you can. So instead of saying, Avery did X, Y, and Z, and having that be your full question, break it down. You can say he did X and then wait for the response. He did Y, wait for the response. He did Z, wait for the response. And it just makes it really clear for your audience. But to end on a high note too, I do think that all of you really, I liked in the opening statements and the closings that you were able to tell stories really well. And I really commend you all for doing this. I thought you did a great job. I will put my email in the chat as well in case anyone has questions. I did take notes. Nice job.
I just have a few more comments. My name's Tiffany and I did mock trial through high school and now I compete in college for the University of Michigan. So trust me when I say I know how much time you guys put into this and it shows. You guys did amazing. That being said, I just have a few comments and I'm sure your guys' coaches tell you this all the time. It's always said, but know your rules of evidence. You cannot know those things enough, I promise. Like an example for the first witness, the detective, the hearsay objection on that, according to Rule 703, hearsay can come in on an expert where it's otherwise inadmissible. So you can really get around a lot of rules just by knowing, or a lot of objections just by knowing that. So make sure you go over that. I think there was another pretty big one. Oh, it was the leading questions one. 611 allows leading questions when necessary on direct, and they were really necessary at that point. So I think you totally would have gotten it in. Just know those funky rules that people often overlook, and that'll get you a leg up a lot of times. As far as witnesses go, I think we kind of snub our witnesses sometimes in mock trial. Everyone's, wanting to be an attorney most of the time because a lot of us are here because we're pre-law, but the witnesses really tell the story of your case. And so they hold quite a bit of weight in your case today. So make sure they're very personable and likable witnesses, which you guys were. You were great. Just make sure they're not like reading and getting too fighty. That was something we saw at times. You don't have to fight on every question. You can act like you're getting along with the crossing attorney, and that's actually recommended. And as far as cross goes, that actually brings up another thing. It's kind of a pet peeve of mine. Even when it's in the question, to the best of your knowledge or ability, it still calls for some speculation. And witnesses, you can just say, I don't know. Like, you have the freedom. If they ask you that question and you're not tied to it in your affidavit, you can say, I don't know what she did. And that can make a huge difference. You don't have to be nailed down to something if you truly don't know. And then the only thing I have for speeches, this is super nitpicky, but just mock trial language, like may it please the court. I heard it in one, I believe it was the prosecution open. Saying may it please the court before you start. It's just a formality that we do. And I don't know, it's just kind of the language you're supposed to use. You just start by, Your Honor, ladies and gentlemen, members of the jury, may it please the court. That kind of opening statement will kind of set the tone, because I thought a lot of times we just jumped into parts and it was kind of hard to keep up with you guys because we were going from one thing to another, which is just a problem we're seeing in Zoom. That wasn't an issue when we were in person and everyone was having to move around, but making sure to keep those phrases in, especially now, is important. But otherwise, you guys did an amazing job, and you guys did, I hope you do great tomorrow.
Alrighty, well, thank you all for your time. Again, wonderful job. We wish you the best of luck moving forward in your competition. Ma'am, I'll let you take over from here.
I'm Amy. I'm the state coordinator for the CBA. So I just wanted to thank you guys for all of your hard work. You're all awesome. Good luck moving forward. And really thanks to all of our volunteers, because we absolutely couldn't do this without you guys. We really, really appreciate your time. Everybody have a good snowmageddon, and I will see teams tomorrow.
Also, before we all leave, on behalf of both teams, I would just like to say thank you for judging our competition and presiding over our entire competition. You guys are really what allows this happen and allowing us a platform.
Yes, thank you so much.
Yeah, echoing that statement. Thank you, Your Honor, members of the jury.
Well, thank you guys. Keep up the good work.